Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Welcome back to a very PMS Monday, a very petty Monday stream, or pissed Monday stream. However, it is my great pleasure to welcome one of my very, very good friends, my YouTube little brother, Flash Fan.
Hey everybody, I'm camera happy today.
It is so good to see you. We have not streamed together in a while. However, today, Flash Fan is my emotional support friend today. Because I am going to need him to get through this Kathy Nestor BS. And I have to go take care of mama duties right now. So, Flash Fan, this is all you. It's your stream. Take it away, my friend.
Yep, so y'all will have Tyler Robinson at the 4-hour hearing. Unfortunately, Squid will be happy to notice that I know she get back. We don't hear from Kathy Nestor this hearing. Her co-counsel speaks. But the motions that were addressed was first the court ruled on the motion to stay proceedings pending interlocutory appeal, a motion to preclude hearsay from the preliminary hearing, and the big motion is the order to show cause that the state violated the gag order. So we had testimony from two of the prosecutors. The elected official testifies, and I don't know if he's the lead prosecutor or one of the second prosecutors testify. But yeah, I don't. But yeah, that's what we have this hearing.
So, I'm trying to convince Flash Fan to start a Kick channel or Discord, or he streams on Discord. However, we need to convince Flash Fan to start a YouTube channel because he is so knowledgeable in these cases, y'all. If he had a monetized YouTube channel, he would be like Emily D. Baker.
Oh, I appreciate that. I hope not. That's a big test.
That is a big test. However, we are going to get started because it is a 4-hour hearing. We are watching it on 1.5 speed. We are going to kind of skip through the lulls in testimony because, holy crap. And if you see me shut off my camera, it's to beat my head against a wall because Kathy Nestor is like...
Yeah, you won't have to worry about that. We don't hear from her. We hear mostly from Richard Novak and Michael Burt.
Yeah, Novak is not much better. Novak reminds me of the West Coast Mark Diller. And if you know Mark Diller is the lawyer representing the O'Keefe family in O'Keefe versus Karen Reed in the wrongful death suit against Karen Reed. And he is the Timu Law School Professor of the Year.
Yeah, I haven't kept up with that stuff. I'm kind of tired of Karen Reed.
I've been watching it on Larry Foreman's channel and like, geez, please bless his precious heart. Oh my goodness. It's like the hamster the wheel is turning, but the hamster is dead. It's like if I got a barrel full of idiots and I paid for a barrel full of idiots and he's the only one that showed up, I'd still get my money's worth. Oh my goodness. I'm working on my Southern insults, y'all. All right. And Kasha, thanks for being a member for 14 months. I hope you're doing well, Squid and everyone. I am doing well. However, we did spend some time at the police department this morning. So on that note, we are going to get started on this hearing. We are watching at 1.5 speed because heaven forbid. We might have to do this in 2 parts because your girl's got to work tonight and lawyers are stupid in general. Not all lawyers, but like sometimes I know they have to make arguments. I know they have to do certain things, but it's like some of the arguments that they make, it's like y'all went to law school for how long and that's the best you could come up with? So with that being said, let's get into this. If at any time you want to stop, just let me know. And you got comments, please let me know. Never feel like you have to wait for me to stop it. Because yeah. I don't feel like I get my Nestor's worth when she doesn't talk. Oh, I feel like they're using Kathy Nestor because I believe she's the only Utah licensed attorney. The other ones are Pro Hoc Vice from California.
Yeah, I know Michael Burt is. I don't know where Novak.
I think Novak is too.
Okay.
So I think Novak is too. I believe she's the only one that's actually licensed to practice law in Utah. So I think they're using her.
This
Hey,
preliminary hearing is going to be brutal next month.
Thanks for being a member for 20 months. Thank you for covering. Yeah, I am covering this, but I can't do these live because we don't have the time or the patience to do these live. So this is where we like do on replays crew and we skip through.
These hearings usually in a regular trial usually last like 20 to 30 minutes. This one,
yeah, everything has to be overdone. I am gonna stop this for a second and share the tab instead, so y'all can see my other stuff. So I still like the saying, "Have the day you deserve." Yeah, my new outro is try not to be a twat waffle. Because
you took a page out of Gabby's book. That's what she say all the time.
Oh, I didn't realize I stole Gabby's work, but it seems to be something I've said in real life all the time. Yeah. So we're gonna get into this. Supposedly, this is the one Flashbang sent me this morning that skips all the gaps and
yeah, they had like 1 10-minute break, and I believe this one was skipped because this is the edited long crime one.
All right, so we're gonna get into
it's
this.
still long, but
yeah, it's still long. But I want to be a 12 waffle. Well, you know. Well, I had the sound
In
off.
addition, the microphones at council table are turned off as a further precaution. And when making arguments, if that occurs, I ask you to approach the lectrum.
All right, they got to go camera off for a minute.
Second, the court will address the camera operator and still photographer. And with those individuals, please come forward to the lectrum.
But I am going to be periodically skipping.
Both of you.
Yeah, that's just the regular routine. Are y'all complying with the
Understand the
camera
order,
order and that crap?
Yeah.
Turning next to the defense motion to stay pending interlocutory review. And the court will issue its ruling on this matter. The proceedings in this capital case, specifically the preliminary hearing scheduled for the week of July 6, 2026. Then
I will be skipping through periodically when people are walking up to the lectern and walking up to councils, like just the little things, because that gives us more time to talk and less time to watch people's backsides.
So I don't know if you covered this motion he's addressing, but the defense filed the motion to stay the proceedings, meaning pause in the proceedings while the Utah Supreme Court reviews the court's order to allow cameras, and that's what he's ruling on. Without hearing.
I didn't. I've been doing a monthly review because there's too many documents in this case. They've been peppering the court.
Oh yeah.
With every freaking, well, they've been peppering the court with documents and documents and documents, and it's like, y'all, like you're not gonna not have cameras in this courtroom unless the camera operators violate the judge's order.
Or the Utah Supreme Court says he made an error, which I doubt they would say that.
Yeah, but they are trying everything. This is why when we talk about people delaying, this is what delaying looks like. This is what delaying looks like. It's delay tactics. You know how to skip like a pro. Sometimes I skip where the judge is talking a little bit too, but when he's talking about stuff we've already known and we've talked about before, I don't think that we need to listen to him talk about it again.
Yeah, essentially what they said with this motion, where they're saying that the usual stuff, it impacts Mr. Robinson's right to a fair trial if on stage of proceeding until the Utah Supreme Court comes back with and shoot it. They ain't even chose to look at the case for appeal yet. They just reviewing it. Yeah,
it's like cameras in the courtroom affected Sarah Boone's right to a fair trial. Yeah. Or Daryl Brooks's right to a fair trial. Or Corey Richards, since this is Kathleen Esther's playbook.
Oh, I will say Corey Richards is mentioned somewhere in some testimony here.
Oh my God. All right, let's get into this. Yes, please give if you can. The attorney this morning, you heard her. Oh my goodness. Yes, and I am not an attorney for those of you who might be catching this on YouTube's algorithm. I am not an attorney. I am an occupational therapy assistant. I just like to trial watch because if we don't know what is going on in our court system, we can't hold people accountable to doing their jobs. And there are so many people in this country who have no idea what happens in courtrooms and how things are supposed to go. And this court or this trial or this case specifically has proved how many people on social media have no idea how our court system works. How many political YouTubers, how many commentators, how many news people talk about things. And it's like, that's not how this shit works.
And this is why you need cameras in the courtroom. I got so many family and friends now who say they think that, oh, you're charged, you must be guilty to state one charge. They're like, no, that's not how that works. That's not how that works.
No, and with the level of corruption that goes on in our country, like, no, like you got the level of corruption is from top to bottom, like every level, it's infiltrated everywhere. And cameras, what is it? Transparency or sunlight is the best disinfectant. Transparency is the way that we make sure that shit is not corrupt. Or when we can see the corruption and we can call it out.
That's why I like Florida and Wisconsin. Wisconsin documents are not easy to find, but they allow cameras in most of their courtrooms.
Yeah, Wisconsin's the Florida of the North. Trust me, I'm aware. All right, and Curbless, thanks for being a member for 11 months. Hey, people, hit that like button. Yes, please hit that like button. It would be greatly, greatly appreciated. Oh, and my stream from a couple of days ago was, for those of you who aren't aware, it was copyright struck. I just got an email from YouTube about an hour ago. The copyright, or not the copyright strike, the privacy complaint. The privacy complaint is gone. My stream is fine. It did not violate YouTube terms of service. So once again, people trying to flag my channel did not work.
Like I said, did you play some music or something that was like?
No, there is one person who is who keeps flagging my channel because they don't like that I talk about them, and they keep every time that I mention them, they privacy flag my channel. And once again, privacy complaint was gone. I got an email saying your content does not violate our terms of service. All that, Yeah. So once again, let's get into this.
the Utah Supreme Court's disposition of his petition for permission to appeal.
I don't know why we had his camera set up.
The state filed objection to the motion, and defendant subsequently filed a reply. Having considered the parties' briefings, the factual record, and the relevant authorities, the court issues the following ruling in order. Defendant is charged with the aggravated murder of Charlie Kirk, a capital felony offense. The media interest in this case is extraordinary within the state of Utah. Due to this intense public interest, defendant previously filed a motion to exclude
Check on my
state
daughter.
photographers,
He'll be right back.
TV cameras, and microphones from the courtroom, seeking a categorical ban on electronic media coverage during all proceedings. On May 8, 2026, this court issued its camera ruling, denying defendant's request for a blanket ban and concluding that under Utah Rule of Judicial Administration 4-401.01, requests for electronic media coverage must be evaluated on a proceeding-by-proceeding basis rather than through a categorical prohibition. The court also established procedures designed to provide advance notice of media requests and an opportunity for the parties to be heard before any such request is decided. Subsequently, on May 29, 2026, defendant filed a petition for permission to appeal from an interlocutory order with the Utah Supreme Court, challenging the camera ruling on state and federal constitutional grounds. On June 6, 2026, the Supreme Court issued an order requesting that the state and various media organizations file responses to defendant's petition within 14 days. Additionally, on June 1st, 2026, this court denied defendant's motion to close portions of the upcoming preliminary hearing and seal exhibits, concluding that defendant had not demonstrated a realistic likelihood of prejudice sufficient to justify closure, particularly where much of the information at issue was already publicly available. The parties dispute the precise legal standard governing a motion to stay pending interlocutory review. Defendant argues that the granting of the stay lies within the inherent and discretionary powers of the court, varying according to the requirements of each individual case. In addition, defense argues Rule 8 of the Utah Rules of Appellate Procedure, which requires him to request a stay in the trial court before seeking a stay from the Utah Supreme Court. Conversely, the state argues that under Rule 8C2 of the Utah Rule of Appellate Procedure, the movement must demonstrate A, a likelihood of prevailing on the appeal, B, a likelihood of irreparable harm to the movement outweighing the harm to any other party, and C, that the stay is not adverse to the public interest. Defendant contends the factors contained in Rule 8C govern the waiver of a bond or security requirement and do not establish the substantive standard for granting a stay itself. The court concludes that regardless of whether the motion is analyzed under the discretionary authority recognized in Lewis or under the factors identified in Rule 8C, the result is the same because defendant has not established either a sufficient concrete threat of irreparable harm or that the balance of equities favor a stay. Defendant argues that proceeding with the July preliminary hearing while his petition remains pending will cause irreparable harm to his constitutional rights to a fair and impartial jury. Specifically, defendant relies upon the expert opinion of Dr. Christine Ruva, who opines that electronic media coverage of the preliminary hearing may expose prospective jurors to an inadmissible hearsay evidence and create unconscious bias. Defendant further relies on Shepard, James, and Hollingsworth, arguing that once the proceeding is publicly broadcast, any resulting prejudice cannot be undone. The court takes defendant's concerns seriously. The potential impact of extensive media coverage in a capital case is neither hypothetical nor trivial. The court further recognizes, unlike many forms of pretrial prejudice, widespread dissemination of information through modern and electronic media may be difficult or impossible to fully reverse once it occurs. The question presently before the court, however, is whether the record establishes a sufficient concrete and imminent risk of prejudice to justify staying all proceedings while interlocutory review remains pending. The court concludes that the asserted threat of prejudice has not yet been shown on the present record to be sufficiently concrete to justify the extraordinary relief requested. The court does not minimize defendant's concerns regarding publicity in a case of this magnitude. Indeed, the court has previously recognized that media attention surrounding these proceedings is extraordinary and that dissemination of preliminary hearing evidence presents challenges not ordinarily encountered in most criminal cases. Nevertheless, extensive publicity does not standing alone establish that an impartial jury cannot ultimately be selected. Courts have long addressed highly publicized prosecutions through established procedural safeguards, including expanded jury pools, detailed jury questionnaires, individualized voir dire, venue-related remedies where appropriate, and careful judicial supervision of the jury selection process. As the United States Supreme Court observed in Nebraska Press Association versus Stewart, pretrial publicity does not inevitably lead to an unfair trial, and predictions regarding its ultimate impact are often uncertain. Likewise, prominence does not necessarily produce prejudice, and jury impartiality does not require ignorance. In its June 1st, 2026 order denying closure, this court concluded that the defendant had not demonstrated a realistic likelihood of prejudice sufficient to justify closure of the portions of the preliminary hearing. Should concerns regarding prejudice arise as the case progresses, this court retains broad authority to employ traditional safeguards to protect defendants' constitutional rights, including expanded veneer procedures, comprehensive jury questionnaires, individualized voir dire, changes of venue when warranted, and other remedies authorized by law. Moreover, no media organization has yet filed a request for electronic media coverage of the July preliminary hearing, and the court has not been called upon to determine whether such coverage will be permitted. Accordingly, the asserted injury presently depends upon future events that have not yet occurred, including whether any request for electronic media coverage will be filed, and if so, how the court will rule on such a request. At this
And that was my point. They're making assumptions about things that haven't happened yet.
Yeah.
That was totally part of my problem. It's like, you don't know that that's going to be a problem. You're making an assumption. And you know what happens when you make assumptions, right?
You give people time to prepare and make sure. I mean, it hadn't happened yet. So we want just to be denied. Like, okay, well, they haven't asked yet. Like, wait, people.
Are you done? No. Do you want to give your 2 cents? Okay. Like, it's one of those situations of, I think the judge, this is my criticism of judges in general. They're wordy. Like, I know they got to be specific, but it's a lot of words to say things that don't need a lot of words.
Yeah.
But the defense is making assumptions on things that have not happened yet. And you don't know. How about if you notice something, we'll cross that bridge when we get there.
Yeah.
No, ma'am. No, ma'am.
juncture, the court cannot assess those contingencies with sufficient certainty to conclude that a stay is necessary. The court recognizes defendants' arguments that the alleged injuries arise not merely from the possibility of future media requests, but from the operation of the framework established in the court's May 8, 2026 order while appellate review remains pending. The court has carefully considered that concern. However, because any request for electronic media coverage remains subject to case-specific review, and because no determination regarding coverage of the preliminary hearing has yet been made, the court concludes that the asserted injury remains contingent rather than immediate. On the present record, the possibility of future electronic media coverage does not establish a sufficient concrete basis for staying all proceedings pending interlocutory review. The court's denial of a stay should not be understood as a determination that the defendant's concerns lack merit. Rather, the court concludes only that the current record does not establish that such concerns have matured into a concrete and immediate threat request requiring present intervention. Given the procedural safeguards available to ensure the selection of impartial jury, the defendant has not established irreparable harm warranting a stay at this time. In balancing the equities, the court must also consider harm that a stay would impose upon other interested parties. The state argues that delay may impair the orderly presentation of evidence, increase risk of fading memories, and affect witness availability. The court finds those concerns legitimate and entitled to consideration. Additionally, the victim representative has formally asserted her right to a speedy disposition of this matter. Under the Utah Constitution and Utah Code, victims possess important rights to proceedings free from unreasonable delay, and courts are obligated to consider those interests when exercising discretion in criminal cases. The court acknowledges defendant argument concerning victims' rights and defendant's constitutional protections. However, because the court has concluded that the defendant has not demonstrated a sufficiently concrete threat to those protections on the present record, the court finds that interests favoring the continued progression of the case weigh against imposing a stay. The court continues to adhere to the reasoning set forth in its May 8, 2026 camera ruling and its interpretation of Utah Rule of Judicial Administration 4-401.01. At the same time, the court recognizes that reasonable jurists may disagree regarding the proper application of that rule in a case receiving this degree of public attention. The court further recognizes that the Supreme Court's request for responses indicates that defendant's petition presents substantial issues warranting careful appellate consideration. The court does not regard the Supreme Court's request as a routine procedure event and acknowledges that the issues raised are of sufficient significance to merit serious review. The court expresses no opinion regarding whether the interlocutory review ultimately should be granted. The existence of a substantial legal question, however, remains distinct from the separate question presently before this court, whether the defendant has demonstrated that a stay is presently necessary pending further review. The court remains persuaded that the procedures established in its May 8, 2026 order are consistent with Rule 4-401.01. Any future requests for electronic media coverage will be evaluated on the specific record then before the court after affording the parties a full opportunity to be heard pursuant to the procedures previously established. Finally, the court concludes that the public interest presently favors allowing this matter to proceed in the ordinary course. The public possesses a substantial interest in the fair, orderly, and timely administration of criminal justice. The court further recognizes that public confidence in the judicial process depends both upon transparency and upon the preservation of constitutional trial rights. The court remains committed to safeguarding both interests throughout these proceedings, staying the preliminary hearing while the Supreme Court considers whether to grant discretionary interlocutory review would result in additional delay despite the absence of a presently demonstrated need for such relief. The court recognizes the seriousness of defendants' concerns and the significance of the issues presented before the Supreme Court. The court further recognizes that concerns regarding pretrial publicity and electronic media coverage implicate important constitutional values and warrant careful judicial review. Nevertheless, the potential prejudice identified by defendant has not yet matured into a concrete and immediate threat requiring intervention in form of a stay. Established procedural safeguards remain available to protect defendants' right to a fair trial should circumstances warrant their use. By contrast, a stay would impose an immediate and concrete burden upon continued progression of this case, including the interests of the state, witnesses, and victim representative, as well as the broader public interest in the timely administration of justice. Nothing in this order should be construed as foreclosing defendant from renewing an appropriate request for relief should further developments materially alter the circumstances presently before the court. Should future developments demonstrate a material difference of level of publicity, media exposure, jury contamination risks, or other circumstances affecting defendants' fair trial rights, the court will not hesitate to revisit appropriate protective measures. Likewise, nothing in this order predetermines how the court will rule on any future requests for electronic media coverage of a particular proceeding. Accordingly, the defendant has not established that a stay of the proceedings is presently necessary or appropriate. It is hereby ordered that the defendant's motion to stay pending interlocutory review is respectfully denied.
Denied. And he took all that time.
It took 10 minutes to deny.
I mean, I like this judge. However, this is my criticism of all judges. And see, there's a thing called the First Amendment that I have that I can criticize judges because I can criticize people just like people can criticize me. Doesn't mean I have to like it. However, it can be done because it's a First Amendment right, as long as you're not harassing people. But I can say that I think this judge likes to hear himself talk or is trying to be super. I don't think, okay, correction. It's not that he likes to hear himself talk. I think that he's trying to be super walk the line because he knows that they're appealing everything and they're delaying everything. He's trying to make everything appeal proof.
I think it's the Utah thing because you see it here in some cases they just rule like, okay, well the defense filed this motion and for the reason cited in the order or whatever, the motion's denied. So I think it's just a Utah thing because other judges out there, I believe, do it too. The Tracy Grist judge, that's Utah, Donna Adelson, took him a long time to rule on stuff.
Well, think Judge Darrow in Wisconsin and Darrell Brooks. She liked to hear. I'm convinced that she liked to hear herself talk because Lord help us. And I believe, don't quote me on the exact time, but I think it was like 6 months.
Yeah, I looked up when he was appointed to the bench. He was appointed in May of 2025.
Yeah, so
new. It's not even been. It's been a year for him at this point.
4 months before the initiation of the case.
Yeah.
But to not have a preliminary hearing over almost a year later, I'm like, I'm not a lawyer, but that's not normal. That is not normal. Yes, this PSA, unfortunately, for court videos, court streams. For those of you who court watch frequently, you know that court audio sucks monkey butt. I can't say anything else because YouTube will eat me, and this one right here will say stuff or get at me. However, I have tried to adjust the mic settings for both, and I keep turning our mic settings down, and it keeps automatically adjusting us. So, even though I keep trying to adjust us, StreamYard adjusts us back to automatic. So I don't know what's happening. I think that's why he's trying to cover his butt so much that he's almost to a fault.
That, and I don't think it's because he's new. I think because this is a capital penalty case. So had to be real careful with those type of cases from what I understand with appeals because any wrong mess up, get this overturned and they're going to have to retry it again. If it does.
It'd be nice if I unmuted myself, right? There's a few reasons that it could be, and honestly, it could be a combination of a lot of things.
Yeah.
He's new. This is his biggest case.
Probably one of his first, if not his second He ain't been on the bench all for this case. Came across his desk.
I mean, capital cases aren't, extremely common. I don't know. I think he's at work. No, he's at work, baby. Mr. Squid started his new job today, so she's having a little bit of a separation anxiety with Daddy. But we're gonna get back into this, and if I have to, I will speed it up to 1.6 or 1.7 speed, because if we have to listen to these people on chipmunk mode, we will. I think the microphone is learning, and you're being taught a lesson. Yeah. It's just every time I edit it goes back to automatically adjust mic volume, and I turn you down. And
it did because all
right
the new stuff you was testing out. Is that why it's doing that?
No, I keep unchecking automatically adjust mic volume, and I turn you down. And every time I go back to your mic settings, it's automatically adjust mic volume is selected again. So I don't know what is happening with your, like, I'll adjust you, and then it automatically
maybe I need to turn my device volume down a little bit.
Yeah, I try that.
There we go.
That might be it. Daddy-daughter calls is instantly more important than his new position. Sadly, not likely, but you never know. Yeah, it's unfortunately not. User error. Hey, P. Thank you. If you're gonna insult, no, just kidding. I was like, hey, P, if you're gonna insult me in a super chat. Just kidding. Like, that's my grift, right? Because people, yeah, I'm a horrible grifter. Horrible.
And that concludes the order of the court as it relates to the stay. Mr. Novak.
Thank you. On the same subject matter, and with respect to the timing laid out in the court's May 8th, 2026 order, we have a concern on behalf of Mr. Robinson that,
Of course you do.
for the court to, well, let me just back up. There has been a request for electronic media coverage in every single hearing in this case.
Oh, shit.
So I think it's fair for the court and the parties to anticipate that there will be a timely, under the May 8th ruling, request for electronic media coverage for the preliminary hearing. The court set up a, what I'll call a briefing schedule for how the parties respond to that request for electronic media coverage. But it appears to us that the court wouldn't rule on the request for electronic media, any request to prohibit or limit electronic media coverage until the morning of the preliminary hearing. And I think that that creates some problems, at least for Mr. Robinson, because if the court were to disagree with the relief Mr. Robinson seeks, we have no opportunity to seek review of your Honor's order. And the court just laid out its acknowledgement that there are serious constitutional issues which other jurists may disagree with vis-a-vis the court's conclusions. So the request is that the court modify in some way the timing of that litigation so that the parties and the media can have and their counsel can have a ruling sufficiently before the first day of the preliminary hearing, so that if some judicial review is going to be sought, it's not happening after the preliminary hearing has already begun.
No, and I
Oh, okay. I really, really apologize for speaking with my hands all the time, because I'm realizing with him how freaking annoying that is. I'm sorry. I speak with my hands because when I was little, I learned sign language. So I speak with my hands because I'm used to like actually speaking with my hands, and not with one hand though. But I'm watching him do this at the judge, and it is freaking driving me up a wall. I don't know, but maybe it's Novak. I think it's Novak. Because I think he just has, I don't know what it is, and no offense, this is not intended to offend anybody, but it will. I will get hate comments for this. California. People from California, like cities in California, not like real California, but like LA, San Francisco, those kind of California. Like the logic there that they just, the attitude that they bring to the rest of the world, especially like Utah, which is considered flyover country, is annoying to me, just in general. I don't know. And AP, thanks for the $5 super chat. User error didn't say whose though. That's true. I mean, but there's only one that it could have been. So, okay, I gotta get comfy because somebody is making my arm go to sleep, but I'm nap trapped. But that's okay. And Malin, thanks for the 20 Swedish krona. Hi and bye, Fee. I hope you have a good night and get some good rest. And Harry, thank you for the $5 super chat. So if we get to insult as long as we super chat, how does it feel to be small with box-sized feet? I don't know. Just like it about as good as it feels to be a obese, uneducated, what else is psychopath stalker. I don't know. Speaking of which, I'm not the one doing the stalking. I'm the one being stalked. So there's that. Oh, Squid is. That's what Mr. Squid says. You know?
Appreciate that, Mr. Novak. I note your concerns, and it is for that very reason that the court modified what was the procedure before, which, and please correct me if I'm wrong, I'm
Dogging all his
going
toy.
off my memory, but the media was required under the rules to give, was it 1 day notice before the hearing?
It was something like that. So, so the notice.
Hold on, I want to finish. Sorry,
Yeah.
but I appreciate you. And so the court expanded that to allow briefing, where under the current rules, as they're stated now, it wouldn't even allow for briefing. It would create a greater issue that you're proposing, because you wouldn't even be able to file a motion, no response and no reply. The intent of the court was to give the parties sufficient notice or more notice than the rule currently allows, to allow briefing, to allow that to be presented, and for the court to consider that as opposed to making a snap decision the morning of the prelim. So the court's coming in with more information than simply the request for media coverage being filed the day before, and then parties trying to come up with an argument, and the court trying to make that decision on the day of trial. And so that's the difference. And the court anticipated that concern and wanted to give the parties that ability to articulate their concerns and allow the court sufficient time to consider those arguments and weigh those arguments against the constitutional rights of all parties and render the best decision it can.
So I acknowledge all that. I agree with all of that. I appreciate all of that. What I'm referring to is Mr.
Can he say one sentence without using his hands? Can he? Can he? And I know this is at 1.5 speed because we are stopping to give our input, and we are going to make this two times through, or 2 different streams, because heaven forbid we do a 4-hour stream with commentary. I don't have the patience for Novak 4 hours. I don't have the patience to be in the same like room as Novak. Like, he doesn't have to be talking for the 4 hours, but like to be, like I said, he's the West Coast Mark Diller. Like, I look at him and I'm just like, how?
Like California attorneys, y'all. Well,
Like,
with the exception of maybe Alan Jackson.
like, well, yeah, Alan Jackson. All of Karen Reed's lawyers, I think, are really good. I don't see any, like, of course, they do some things where I'm like, why would you do that? But it's not egregious to the point where I want to like beat my head against the wall. Whereas there's always like, yes. And Mom, what did you do to my child this morning? Because she, girl is out like a light. But I don't have the patience to listen to Novak talk for 4 hours. So
He's for 2 hours. Michael Burt. He's for 2 hours, and Michael Burt is 1.
This guy right here, I don't know who he is for the prosecution, if he's a lawyer or if he's a paralegal or legal assistant or something. I don't know who he is. But when Novak started speaking, he sat back in his chair and tipped his head. Like, I didn't even have to see his face. Know that there was like a, what the hell does he want now kind of look on his face. Like, do you ever know, like, even from the back of someone's head, and the way they have their head tipped and like their back and their body language and their posture, you would just tell that their emotion is written all over their face, and it is
It
like
in classic trial. Well, in classic trial,
it's
they
the male version of a WTF face.
if I had $1 for every time in a classic case, like for instance, California, with the Menendez case, every time that judge had to tell one of the defense attorneys, like, okay, counsel, let's not make these comments about how the other side is doing and how annoying they are.
Yeah, well, and the judge just seems a little perturbed because he's like, I'm giving you more time than what the rule says I have to, so you're still bitching.
Yeah, isn't it like
Why are you still
6
bitching?
days before the hearing, and they like, we want more. Like, be happy with what you got, man. He can be heard.
Yeah, I'm gonna restart this, and I'm going to go put her in her bed because I literally cannot hold her because if I move my fingers, she's going to fall, and my arm is falling asleep. So, yeah, Gail, mine does too. Well, if you haven't noticed, mine does too. It's one of the reasons, like, okay, I don't think my channel would be as big as it is. My channel is not that big. I only have 4,300 subscribers. I'm not trying to say that my channel is large. However, I think I would still be at like 1,500 subscribers if I had a poker face.
Not to go on that topic, but if you go to court, how are you going to be able to maintain your emotion and the way you quit?
Taking notes. Taking notes. I did. I did not see a raid, but I'm also not looking at my YouTube studio, so I did not see a raid. However, I appreciate y'all for hanging out, and I'm going to try to go put my child in her bed, and before my arm falls off and she falls.
Hey, Spawn, I didn't see you because I'm not looking. I'm trying to deal with a dog. I didn't look at the chat.
So I have someone who is sleeping.
Robinson's, or depending upon how the court
I'll be
rules,
right
the
back.
state or the media's opportunity to seek interlocutory review. If, as Your Honor states, it is true that what has to be shown is the harm under facts that relate specifically to the preliminary hearing. Okay, so the court has denied what I'll call a more general blanket request to preclude electronic media coverage. The court has said it's going to take it up on a hearing by hearing basis. And the court has also said that reasonable jurists may disagree with the court's substantive conclusions and the court's ruling on our request for a stay. And what I'm suggesting respectfully is we may be in the exact same place. One of the parties may be in the exact same place in the moments before the preliminary hearing, at least presently, is scheduled to begin on July 6th. So my question is, can we get a ruling from the court sufficiently before July 6th so that if some party seeks a stay and interlocutory review, we're not doing that on July 6th or July 7th or July 8th, because by that point in time, it's too late. So we could have a ruling by WebEx. We could have argument and ruling by WebEx. I totally respect that the court has a very busy calendar. And I also understand that the preliminary hearing is starting 2 days after the 4th of July, which this year is a big deal. So what I'm trying to just do is plan ahead and think about whether the schedule that the court set, which we agree makes a significant difference in our ability to litigate before Your Honor the issue, a way to resolve this so that we also have the ability to seek review before it's too late.
No,
I'm literally talking about the last few days of the week before. That's, I think, what we're talking about.
And I appreciate that. And where I'm coming from is the court cannot issue anticipatory rulings. I can't go off hypotheticals. And I understand what you're saying. I recognize that media requests have been filed, but I can't issue a hypothetical ruling. It has to be squarely before me. And I respect what you're saying, but I imagine that you're probably preparing. Well, I'm not going to assume it's not appropriate, but perhaps you are already preparing those motions in anticipation of such media requests being filed. And in addition to anything else that you may consider, and rightfully so. And so and there's also sufficient time between now, given the ruling that the stay is not being granted, knowing that the preliminary hearing is moving forward, that it appears that there may be sufficient time for the parties to prepare accordingly. Again, the court needs to wait until it's squarely that media request is been filed. Whether the parties file motions, it's possible that the parties may or may not. I can't anticipate that, but I need to wait until it's actually before me, as opposed to trying to read the tea leaves and guess.
I'm not asking the court for tea leaves, so maybe I've been obtuse. What I'm saying is that the court's order currently provides that it will issue its ruling on any objection to an EMC request.
Maybe we need to be more clear, man.
And that's the problem. I'm not asking the court to issue a ruling now. I'm not asking the court to assume there will be an EMC request. I can tell the court that if there is an EMC request, we will file an objection to that, which shouldn't be a surprise. And so what I'm just saying is, for the order of the administration of justice, and in light of the possible judicial divergence of opinion that Your Honor has acknowledged, we are asking the court to build into the schedule that it has set for any objections to any EMC request that may be filed, a period of time before the subject hearing at which the parties would receive a ruling. If I suggested in my statements that we are actually asking the court to assume that there's an EMC request and that we would oppose it and that we're asking for a ruling now, we're not. We think there should be a request and there should be briefing. We're just asking that the court build into the schedule a ruling moment that allows us, if necessary, or some other party, if necessary, to seek review.
Thank you, Mr. Novak. And the other kind of X factor is how quickly the parties respond. If a motion is filed, and let's say an EMC comes out on day 1, and a motion is filed on day 2, and then the state files on day 3, there may be more time. And so one of the variables is how quickly the parties respond, which the court doesn't control. And so that's a factor that may allow the court additional time to accomplish that. And this court has tried to be very.
I take it you have an opinion, sir.
Huh? Oh, I thought
These-
me?
Yeah, you.
Yeah, I thought I was muted. I was yelling at the dog.
You
trying
were.
to be quiet, like get in the room.
This.
But yeah, I do. He's irritating.
I mean, yes, no. And this is one of the reasons that it's like Novak. Like dude.
All California attorneys are not this bad. Trust me, I've seen California attorneys. At least the classic ones. I don't know how they are now because they don't talk about it.
I don't know what it is, but okay. I have no idea what it is. But it's like, you know how the phrase the squeaky wheel gets the grease? It's the most annoying or incompetent lawyers that get the media coverage.
Yeah, like James Owens,
Oh my God, James Owens.
John Pryor for Chad David, all those who watched that a couple of years ago.
Mark Diller. It's like all the oh my God. Oh, it's like there's gotta be some good ones out there. There has to be. But it just seems like the more trials we watch, the more the stereotype of lawyers becomes a reality. Like I don't like to stereotype people, but stereotypes exist because people fit into them.
Yeah.
They exist for a reason. Not because everybody fits into them, but because
I used to like defense attorneys. But the one that is late, I'm like, come on, man.
It brings up the question, and this is what we do on this channel. We just ask questions. And we don't always have the answer to the questions that we ask. It just makes you ponder things in life. Is it the fact that the defense attorneys are seeming like they're worse and they're asking worse questions and they're writing worse motions than we've ever seen? Or are the clients just worse? Are the cases and the facts of the cases just worse?
I mean, with all this so-called evidence they say they have, I mean, for Christ's sake, they got a preliminary hearing set for a week, an entire week. So that proved they got a lot of evidence. So I'm like, what defense are you really going to use? So I'm like, they kind of probably have to try to delay. Maybe it's a strategy. I don't know.
And at what point do guilty parties just admit that they did something wrong and, or are we going to see a Koberger where it's innocent, he's innocent, he's innocent, he's innocent, he's innocent, and then at the last very second, he pleads guilty in order to not have to go through the death penalty? I
will say the defense does ask for something in this case. I ain't gonna say what, but I'm like, oh, that's how they're trying to get around it. I'll just leave it at that one because I wondered if that was gonna come up.
And this is all conjecture on my part because I did not watch this. Because if I'm going to watch, this is the thing. If I'm going to watch lawyers who I know I do not like, I'm only going to do it once. And you get to see my real reaction to what I think of the situation. Because I don't know why Novak annoys me so much. I think it's the California. I think it's the I'm smarter than you. And this is the thing. There are certain people in the world who, like, I know I'm not the smartest person in the room. Well, I am now because I'm literally the only person in the room. But that's not the point. It's one of those situations that the only way to, in my opinion, the only way to become a better person and to be humble in life is to walk into a room and know that you may not be the smartest person in the room. You might have the most knowledge in a particular area of life. Like Flashman, I might know more about being a mother than you do because the obvious.
Yeah.
However, that doesn't make me smarter than you as in life as a whole. You know what I mean? That kind of a situation.
Yeah.
And I just get vibes from certain people that think because they're smarter in one area of life, that they assume that they know everything more than you. And that, like, that attitude, I can see it written all over someone's face, and it just irks me. And it's like, it's how I instantly read people. And it's like, do I click with someone, or do I think that I'm gonna hate this person?
With some of my viewpoints, I'm surprised you keep me around sometimes.
Well, no, it's we disagree on some things, but we discuss them like adults.
Yeah.
And when we don't agree, we understand why we don't agree.
Yeah. It's not like how some people, they disagree, and they're like, instead of saying, "Oh, we'll agree to disagree," or something like that, they're like, "Oh, you this, you that." Like, whoa, why you gotta be all that? Why you gotta call me a name?
Or
Agree with you.
Or we say, I can understand your viewpoint from your life experiences. I don't have those same life experiences, but here's my life experience that has led me to think the way I think.
Yeah.
And we learn from each other.
Kobe, don't chew on the sock.
Novak just reminds me of that person who like walks into a room and says, I'm the most gorgeous looking person and I'm the most educated person in the room. And like, it's like, I might not be the most educated in the law because I'm not a lawyer, but I have a college degree. So like, you know. Okay.
And I like reading cases. Don't make me a lawyer, but I like reading them and trying to interpret them now. Am I interpreting it correctly? Probably not. But
Like I told the cop this morning, because she was talking to me and I was like, I just like knowing what goes on in our legal system.
Yeah.
And I read legal documents because they're public. Yeah. And if things are public, I believe the public needs to actually see what's going on and what people are saying and doing. And, if you put things in legal documents that like are, if you're embarrassed of what you wrote in a legal document, maybe you shouldn't have written a legal document. Like Kathy like Novak, I'd be embarrassed at some of the documents that I wrote in this case. Like I would not want the documents in this case made public.
And the crazy part is these attorneys aren't new. They've been attorney for decades, at least 30 years. I know Nessa's been there since 92. So.
But here's also the thing. Have they, just because you've been a lawyer for so long, like I always go back to what I know, the medical field. I know people who have been therapists for a long time. And they might be good at what they do, but they suck at writing. Yeah. And it's like, you've been living under the status quo because no one's been there to check you on your shit. Yeah. No one's been there to criticize your work. So you've been able to get by because no one's been there to say the quality of this document or the quality of this note and the quality of your treatment sessions isn't really up to what it should be for the amount of money that you're charging. And now that people are getting more interested in reading public documents, obviously we can't read, medical documents because of HIPAA, but you get my point. Like, you know what I mean? kind of the same. But when we started going through when I worked and doing case reviews and note reviews, and you would get checked on how you wrote your note, how thorough you were, what treatment you did, what you picked, how good your treatment was compared to what you're supposed to be doing and what your goals were. People started getting better at their jobs because they were evaluated.
You would think if somebody in the law firm would be like, hey, this filing you filed, it doesn't make sense, or you left this out or something like that. You think they would get advice on that, these filings, these motions that they file, especially if it's like 20, 30 pages long, like they always do.
We had chart review committees. We would be given a list of therapists. You'd be given a list of 10 therapists that you'd have, well, I don't know about 10, but you get my point.
Yeah.
That you'd have to go through, and you'd have to pick a couple. You'd go through their charts, and you basically answer questions on how they were doing and submit it. So it's kind of a, that you gotta, it's a situation like, I don't know if there's anything like that for lawyers, but I think there should be.
Yeah.
So, and thank you to the family of Jeff Grady for the $50 Ko-fi. I appreciate you so very, very much. And also Ninja Puppy, if you're watching, thank you for the $10 Ko-fi from the stream last night. I did not see it at the time. I appreciate your support so very, very much. So
I need to catch some of your nice drinks. I'm always eating dinner around that time.
9 o'clock?
Yo,
Dude, I do that 9 o'clock stream and then I go to bed.
My family cooks late because my sister doesn't get home till 6, 7 o'clock.
Oh, yes. Sorry. I gave the update when I was given permission by the family on Spawn stream. However, derailed stream, pause, timeout. Jeff Grady had his second round of surgery today for the other thing that he was dealing with. And he is out of surgery. He is in the recovery unit. He is doing as well as can be expected. And I just wanted to let everybody know. And his family is very grateful for the well wishes and support from this community and Spawn's community as well. I know we have a lot of overlapping people. However, I am grateful for them. And I am so happy to hear the great news.
That's great.
You were not timed out. I had said hi in your chat like 3 or 4 times before anybody acknowledged that I was there. So like, I thought I had messaged Katja and she said she didn't see my
That's you two do stupid crap sometimes, unfortunately.
Yeah. So it's kind of a thing. So we're gonna get back into this.
Diligent in being in expediting addressing motions and not letting them sit too long, because I know it's important to defense and to the prosecution.
Phone in the courtroom right
Is
that was mine.
cognizant of that and will respect that and issue its rulings or its analysis as quickly as possible to afford you that ability.
So the court did set deadlines for briefing. And what I will do when there's an appropriate break in today's proceedings is we'll speak with counsel for the state about whether we can agree to modify that briefing schedule that the court set so that the EMC request and the parties' responses to it can be submitted to your honor more in advance, further in advance of July 6th than the current schedule allows. And then if we can agree on something, or if we can't, we will let the court know that. And I'm still going to ask the court to look at its calendar and suggest a hearing date, if necessary, on what I think can fairly anticipate will transpire. Again, because the media has requested that their cameras be present at every hearing. And it would seem to me that they would not miss the opportunity from their point of view to broadcast the preliminary hearing.
Thank you, Mr. Novak. I appreciate you addressing those or bringing those concerns
So we'll
up.
bring that back to the court at the appropriate time today.
Thank you, Mr. Novak. Does the state wish to be heard on this issue?
AKA, we're going to bitch again and again and again and again.
They're going to file
And
an
again.
objection to media being present for every hearing. I
We're
guarantee.
going to bitch every freaking time because that's what we do.
even assuming that there's a request for electronic media coverage, which the state fully assumes there will be, and that the court grants that request, the equities as far as whether or not to stay things to allow the defendant to then appeal that ruling, that's really not going to change. The circumstances that the court's already articulated in its order today, those equities really aren't going to change between now and the preliminary hearing. And the appropriate procedure for reviewing a court's orders on electronic media coverage is not to pause the trial proceedings and allow defendant to seek interlocutory review of every order. The defendant can certainly do that. He has the right to do that, but that's not the appropriate remedy. I just remind the court of the United States Supreme Court statement in Chandler versus Florida, where it said that the appropriate safeguard against potential prejudice from pretrial publicity is the right to demonstrate that the coverage compromised the ability of the particular jury that heard the case to adjudicate it fairly. So defendant's claiming he doesn't have a remedy. He does have a remedy, and the remedy is to challenge the court's media order at the plenary appeal after this case is complete. Thank you,
Mr. Ballard. All right, anything further before we move on?
And see, look at that. See how quick that was?
Yep.
Straight to the point.
Yeah.
And I don't know why, but I'm finding myself liking prosecutors more and more. And before I started my channel, and I was just trial watching for fun, being in chats, Emily D. Baker, Rackets, Mo, I hated prosecutors because I hate the state. I hate the government. I am an anarchist, to say the least. And I hate judges. It is my opinion that the judge and the prosecutors are both actors of the state. They are on the same team.
Yeah.
I'm always hypercritical of prosecutors and judges because they are on the same team. However, I have found myself siding with prosecutors more and more and more and more over the past 2 years.
Me too, unfortunately. And I'm not a fan of prosecutors because the people like Karen Reed and Douglas Carter pending out of this same courthouse with convictions from decades ago. So I'm like,
and for a fan, you will have to join me on Friday when we just do an F It Friday, because I need to discuss with you what you think about, and you might want to grab some alcohol for this, because I want your opinion on Michael Proctor.
oh, Jesus. Yeah, I don't know all the accusations, but I heard it's rough, man. I heard it's bad.
Yeah, it's bad. And I would like your opinion because of reasons, you know?
Yeah, that's the thing that set me
because of reasons that I don't.
From what
I have opinions, but I don't have the insight that you have. Flash tipsy, I need to be there. He's probably not going to get tipsy. However, it's just one of those things of
I'll just probably be gritting my teeth.
Yeah, and I have been hesitant to talk about this situation because I was pissed. However, I've listened to it enough times where I think my attitude can stay somewhat in check, enough to make fun of him and give him the appropriate amount of criticism, and let everybody know how shitty of a human being I think he is without it being profanity laced, like the first time that I heard it.
Proctor is the modern day Mark Furman from the O.J. Simpson case.
No, he's worse.
Oh, wow.
Worse. Yeah, it's worse. So, yeah.
Wow.
But we'll have to do that on like Friday or Saturday or something. So, yeah. Yeah, Snipe, you could join too. So, I know Flash doesn't drink, but for these text messages, I'm thinking that
I'm gonna have my my sister got. I'm not a big fan of I said I'm mad because it looks like it's in a wine cooler bottle, but you can only drink sparkling water. She got this thing apparently with a 90s drink, something called Clearly Canadian. So I'll probably have one of those.
that's just water. Just water. All right, let's get back into this. We'll have to talk about that at a later time, but we'll have to plan it.
Yes. We can take this up whenever the court wishes to take it up. And in addition to the two substantive issues, which the court countered for today, which is the hearing on the court's issuance of an order to show cause or contempt, and the argument of a pending and fully briefed motion concerning the constitutionality of hearsay evidence in a preliminary hearing, Mr. Robinson filed with a motion to classify a document, which I'll just describe as having privately been filed, seeking certification for an out-of-state subpoena for the preliminary hearing. And the court is nodding, so I understand that the court is aware of it.
I've reviewed that.
Okay, so again, because of timing issues,
Because that's under seal.
What gets me is the constitutionality of hearsay at a preliminary hearing. He's been a lawyer long enough. A simple Google search will tell you that all they need at a preliminary hearing, it's also known as a probable cause hearing.
Yeah.
And probable cause can be hearsay. I mean, I'm not a lawyer, but a simple Google search, like Google, I'll have to look it up on Cornell Law Legal Institute, because Cornell has the best legal information non-law school for dummies.
And the crazy part is the lawyer who argued that one is Michael Burton. He definitely got experience with these type cases, right? The Menendez brothers and stuff back in those days. He had extensive tried extensive capital cases and stuff before, so he ain't new at this. He's been an attorney since the early '80s, late '70s. He's been
It is just a constitutionality of hearsay at a preliminary hearing. I'm like, most preliminary hearings take 20 to 30 minutes because all you need is probable cause.
Yeah, but usually the lead detective and a couple of civilian witnesses, and that's about it.
Which is like one of the reasons that makes me go, you're stalling. You're doing this on purpose. You are stalling.
Well, I mean, it's not the defense fault for the preliminary hearing set for a week because the state is the one that's providing evidence. I'm like, why y'all providing a week of evidence? I don't know. But that just proved they got a lot of evidence to get them.
True. I get that, but at the same time, it's...
Yeah, I don't see this going to trial for a couple of years.
No.
I feel this going to be one of those cases like Corey Richards, Courtney Quinney out of Florida, and
oh my God, Courtney Quinney. Holy crap, there's a shit show and a half. It's like Sarah Boone 2.0.
She asked for bail every week.
Oh,
I don't like
God.
Court Richards did the same thing, asked for bail like every other.
At least Sarah Boone had the wherewithal and the cognizance to know not to ask for bail because she wasn't going to forgive.
Yeah, no.
I mean, Sarah Boone had a lot of faults, but at least that wasn't one of them. Let's get back.
we would like at some point today to receive from the court a briefing schedule on that, because out-of-state enforcement of a subpoena, if the court certifies it, is obviously something that takes a little bit of time. And in light of the court's denial of the stay, for the moment, we have to assume that if that certification is granted at our request, and by the way, we've served counsel for the witness with that request as well, that we need time for an out-of-state counsel to appear in the appropriate jurisdiction and get an order enforcing that. I can't imagine that if the court granted the certification that there's going to be an issue about serving the witness, but we don't have a valid subpoena unless Your Honor certifies the application and then a court in the appropriate jurisdiction enforces.
Thank you. And I note that that was filed last night around 8:04 p.m.
It was.
What you're referring to?
Yes, that's exactly what I'm referring to.
All right. Thank you. We'll
Exactly
take
what I'm
that
referring to.
under advisement and figure out. Court will address that at some point today.
All right,
Thank you for bringing it to the court's attention, Mr. Novak. All right. Let's continue on.
And he is talking this slow, and we are on 1.5 speed. This is why I can't listen to this man in real time. And this is also why I do petty speed play or petty play. Because we can listen fast. We skip the sidebars. I skip through 5 seconds when they're walking through. We're walking up to the lectern because no one cares about seeing their ugly asses.
Yeah, this is Utah. They gonna always talk slow. This is
She's
that.
from California.
No, the judge. Oh, I thought you were talking about the judge that was
Oh,
talking slow.
No, freaking Novak was speaking that slow
Oh.
on 1.5 speed.
Well, yeah, I don't know because California they talk fast. Alan Jackson had to be told slow down multiple times in the Karen Reed trials.
Yeah, but that's because Judge Bevy is the. Did Megan Fox ever put Judge Cannoni on her wall of shame? I never did ask her because she used to have like a judge's like wall of shame. She had the judge from like Missouri or whatever on there. She had Judge Grudge from Florida. She needs to put Judge Bev Cannoli.
We need a Judge Arthur in this case from Carly Gray.
Oh yeah.
The defense was.
I have to look at what the if the Supreme Court of Mississippi came out with a ruling yet.
Yeah, with all these things getting overturned, Adam Montgomery and people like them, I'm like, yeah.
Oh God, Adam, that's all. Yeah, and that's all. Another thing that we need to do is that's another topic I need to do is just the cases that have been overturned.
Yeah, this is the year of overturned cases for some reason.
Yeah. All right. Let's see what the judge has to say.
Counsel for the state, could you provide a brief status update regarding discovery?
Yes, 2026, we sent 11 additional items to the defense.
Oh, Mr. McBride, if you wouldn't mind starting over, and yeah, that's where the live mic is. Thank you.
Understood, thank you. Ryan McBride for the state. As of June 9th, 2026, we sent 11 additional items to the defense. 10 of these items were notebooks that were obtained and requested from the defense in the discovery review. One is an 1102 statement that was provided in preparation for the preliminary hearing. This is essentially everything we have from the investigative agencies to date. The percentage provided to the defense is approximately 100%.
Thank you, Mr. McBride.
Hey,
All right.
quick,
Turning to
straight
the
to the
defense
point.
motion for an order to show cause for alleged contempt of court. This is set for an evidentiary hearing and argument.
And this is where we will get
Has
into
been
witness
reviewed, briefing.
testimony.
All right.
Submitted. Each side will be afforded 90 minutes to present evidence and argument. If defense intends to reserve time for rebuttal, counsel should plan accordingly. Following argument by defense or a presentation of evidence, the court will take a 10-minute recess and then turn to the state. Because this is the defendant's motion, the defense will proceed first. Mr. Novak.
So this is where I think we're going to do the 90 minutes of the defense, and then we're going to stop and we'll come back either tomorrow, probably tomorrow. And
So the first prosecutor testifies, and then they take a break, and then the elected official Jeff Gray testifies.
Okay. Well, what I'm saying is we'll do all of the first 90 minutes
Okay, the defense is
people, and then
okay.
we'll cut it for today
Okay,
because I have to work,
yeah,
and then we'll do tomorrow. That way we're not trying to cut it in the middle of somebody's testimony.
yeah.
So that'll be a good stopping place for this stream, and we'll come back and we'll do the rest probably. Are you free tomorrow?
Yeah. I got in Court Watch. I have a Menendez episode. That's 2 hours. I can finish that with increased speed because it's from the 90s. So,
All right. Sounds good. So about 2:30 tomorrow, we'll come back and we'll do the other part of this.
okay. Yeah, we got about 2 hours of testimony today now.
All right.
Thank you, Your Honor. Mr. Robinson would first ask the court to direct Mr. Ballard to take the witness stand.
All right, Mr. Ballard, if you wouldn't mind coming forward and being sworn in. All right, Mr. Ballard, if you're
Thank you, Your Honor. Mr. Ballard, what are your formal titles within the Utah County Attorney's Office?
I am the general counsel and public information officer.
I believe the audio gets better in a second.
You're testifying here today because the court has issued an order to show cause regarding contempt of a court order. And so there's a white notebook that I placed up there. Do you have that, sir?
I do have it.
All right. Why don't we first turn in that notebook, and Your Honor should have one as well.
I don't.
I passed it up
Oh,
to
there
the
it
clerk. Mr. Ballard, why don't you turn to Exhibit 8?
I've seen it. Thank you.
Okay, is this the order entered by this court on September 16th of 2025 entitled Protection Order Re Pretrial and Trial Publicity?
It appears to be yes.
All right. And Your Honor, I understand that a court exhibit doesn't technically need to be received into evidence. Of course, the record is what it is. I could take judicial notice of it, but I just think for completeness of the record, would the court mind if we ask the court to receive Exhibit 8 into evidence?
To the state, any objection? All right, and if you wouldn't mind, so if, as I turn to both parties, because your microphones are turned off, if you wouldn't just mind projecting a little bit more so the record picks it up.
Okay.
Thank you, Mr. McBride. All right, so is this going to be defense exhibit number
8?
All right,
They're pre-marked, so we'll just stick.
just sticking with those numbers.
I think it's easier for the record than changing the order.
I appreciate that.
All
All
right,
right,
thank you.
defense exhibit 8 is admitted and may be published.
I think. And Mr. Ballard, did you read this order either the day it was entered or shortly thereafter?
Yes.
So you were aware of it shortly after it was entered, correct?
Yes.
All right. Why don't we also turn now to Exhibit 9?
And I'm going to be skipping through his turn too.
And same question, please let me know if you've had a chance to look it over.
I've looked at it.
And is this an order clarifying, let me be more clear, an order of this court dated December 15th, 2025, clarifying at the state's request the order that is now Exhibit 8?
Yes.
And could the court receive into evidence, please, Exhibit 9?
Thank you, Mr. McBride. With no objection being made, this is entered into evidence as defense exhibit.
2 orders. Would you agree with me that, subject to the clarification, these orders track Supreme Court Rule of Professional Practice 3-3.6?
Yes, they track that rule. They require both parties to abide by that rule.
And would you agree with me that you are a prosecutor also subject to Rule 3-3.8?
Yes.
And that everybody in your office is a prosecutor under the, within the meaning of 3-3.8?
The attorneys in our office, yes.
The attorneys in your office, right. And again, Your Honor, these are rules of professional practice, but I'm going to ask the court to receive into evidence for purposes of this hearing both Exhibit 10, which is a true and correct copy of Rule 3-3.6 with its comments, and Exhibit 11, which is Rule 3-3.8 with its comments.
With no objection from the state, defense exhibits 10 and 11 are admitted and may be published.
And Mr. Ballard, were you familiar with these rules prior to the court issuing the orders, which have now been received as Exhibits 8 and 9?
Yes.
So would you agree with me that you knew what was required under the court's pretrial publicity orders?
Yes.
Did you have any inability to comply with those orders?
No.
And again, please let me know when you've had a chance to look it over and familiarize yourself with it, that you sent to counsel for Mr. Robinson on December 22nd, 2025.
Yes.
And the subject of this email was your notice of intent, I'm sorry, the state's notice of intent to conduct non-destructive testing, correct?
Correct.
All right. Your
Oh my
Honor,
God,
before I
here
go
we
any
go
further, could
again.
the court please receive into evidence Exhibit 2?
Mr. McBride?
If I can have just a moment. All right. No objection, but as it goes to publication, this includes email addresses. If this is made public, those email addresses should be redacted.
Mr. Novak?
We will provide the court with a redacted version of the exhibit that masks all of the emails that are email addresses that are listed at the top of the exhibit.
All right. Based off the state's not making an objection, but requesting a redacted version with removing emails, defense exhibit 2 is admitted.
Thank you. So, Mr. Ballard, just so the court, because the court has probably never seen this email, I want to go over with you the context and the purpose of this email. The state had determined back in this time period, which is December of 25, that it wanted forensic examiners to do some further testing of a bullet, jacket fragment, and lead fragments, correct?
Yes.
And under a prior order of the court, it was the state's responsibility to notify Mr. Robinson's defense counsel of any testing which may, let's just say, change the nature of the physical evidence.
Correct.
And so what you were doing in late December of 25 was notifying us privately that the state intended to conduct some additional testing, correct?
Correct.
And you state in this email that the reason why you don't want to publicly file this notice of intent to conduct further testing, at least at that time, was because of a comment to Rule 3.6. That's the same Rule 3.6 that the court has received into evidence as Exhibit 10, correct?
Correct.
And what you say is that
Is there a point to this, or is he just like to hear himself talk to?
Ah,
I
man.
know there has to be foundation. I get it. People are, my haters who think I can't talk about legal stuff because I'm not a lawyer. Welcome to the First Amendment. You went to law school. Did they teach you about the fucking Constitution? Because I went to high school and they taught us about the fucking Constitution. So there's that. But I know there has to be foundation. I'm not fucking stupid. However, there's just got to be a better way to do it.
It's the Utah way. If it's anybody else from any other state, I don't know, he's California, so I'm like, you could be more exciting with this and project your voice a little bit. Something.
I don't know if it's his, yeah, it might be his voice too. I'm not gonna lie. Like it's not exactly, I smoked a pack a day in high school, but it's approaching it. Like
They
I
got-
am like,
They got the California attorneys that will fit well in the Utah court system because of how slow they talk. They got
and
the,
this, to anybody who doesn't live in the States, this is why every state is like its own little country, because we all make fun of each other like we're our own little country, because we all have our own weather, we all have our own culture, personality, traditions, and weird people.
and Utah, they're taught slow. It's not to make this political because it's not. It's Mormon country, so they had the priest type voices. That's why they taught this.
But he's from California. Like, dude.
Yeah, I keep forgetting.
I don't know, California people kind of annoy me sometimes.
I
So,
keep trying to defend him. I keep forgetting he's from California.
Kathy Nestor, as far as I'm aware, Kathy Nestor is the only defense attorney who's actually a Utah licensed attorney,
Wow.
which is one of the reasons that I think they're just using her for her license.
He got all these profile attorneys done. I wanted to see how he's paying for it. Apparently, the state is paying for it. So I'm like, this is crazy. The taxpayer dollars are paying for his defense attorneys. I'm like, woo. Because they don't come cheap.
Mm-mm-mm. I don't know. I don't know.
comment to Rule 3.6 of the Utah Rule of Professional Responsibility lists, quote, the performance or results of any examination or test, close quote, and, open quote, the identity or nature of physical evidence expected to be presented, close quote, as subjects to avoid in public comments. Those were your words, right?
Correct.
And then I would also now like to ask you to look at exhibit. And I know I will sound repetitious, but please look it over and let us know when you've reviewed it.
I've reviewed it.
And is this an email that you sent to one member of Mr. Robinson's defense team, and then it appears that it was copied to other attorneys? in your
Mama
office?
duties. I will be right back.
Correct.
Yep.
Your Honor, before I go into the details of it, could the court please receive it into evidence as Exhibit 6 with the same proviso, which is that we will provide the court at a later time with a redacted version that masks the email addresses?
No objection, but the email addresses are not included here. So
Well, there is one at the very bottom of the signature for Mr. Ballard.
thank you. Excuse me.
No worries.
And Ms. Visser's below that as well, Your Honor.
All right.
But I think we're all on the same page about what to do.
It sounds like it. So that Stacy's, I'm sorry, Defense Exhibit 6 is admitted with the following redactions being noted. Thank you.
Okay, so Mr. Ballard, in this email, you're informing us that the state no longer believes that filings concerning this additional testing from the state's point of view should remain private, correct?
I don't recall exactly the question that Ms. Visser had posed to me and that I was responding to. The email speaks for itself.
Okay, so the email says in the top paragraph, but now that the court is involved, we do not believe that it is necessary to keep court filings private or even file redacted versions on this issue.
That's correct.
And this issue refers to whether the state can proceed with the further testing and Mr. Robinson's objections to the way in which the FBI wanted to do the testing, correct?
Correct.
I mean, basically, okay, so that's that dispute. What you say in the second paragraph is the ethical rules on pretrial publicity apply only to extrajudicial statements, right?
Correct.
And so what you're saying is that if we talk about physical evidence, testing that has been done, testing will be done, what the results of the testing are, if we talk about those, we mean in counsel who are subject to the rules and the court's orders in filings, we're consistent with Rule 3.6, right?
Correct.
But if we talk about them extrajudicially, that's prohibited under 3.6.
Correct. Unless we're talking about public records. Unless we're talking about a filing.
I'm not sure what you are modifying with the word unless, and I'm not trying to be difficult. Are you saying that you can make extrajudicial statements about anything you want that's in a public filing without violating Rule 3.6? Is that what you mean?
What I mean is exactly what the rule allows, and that says that a lawyer may state information contained in a public record.
Basically, he's saying I'm a Utah attorney and you're not, and I know the rule better than you. I mean, and he said an attorney may talk about whatever's in a public record, just like anybody else in the world can discuss what's in a public record.
Yeah. I can see it was filed in the seal.
Public record.
But it wasn't filed in the seal, so.
Well, was it the one that was filed under seal and then later released? Because there was a couple that were filed under seal and then they were released later.
Yeah, I don't know. I ain't getting to this case till this beginning of this year.
There has just been so many documents in this case that it's honestly just hard to keep up. It is just, and Heidel, my other channel is back at $3.99. There was somebody who unsubscribed yesterday. So, so we hit 400 for a momentary second, and then we're back at $3.99. But that's beside the point. With that being said, this just was the snarky answer. I'm doing what the rule allows me to do. I mean, as much as I like when it's professional snark. Snark is fine when it's professional snark. When it's I'm doing what the rule allows me to do. Basically, I know the rule better than you. I'm a Utah attorney. You are not. You are pro hoc vice in this state. Welcome to Utah, asshole. Like, it's one of the other things that makes the U.S. a very interesting place. Because of the fact that every state is like its own little country, you can be a licensed lawyer in the U.S. just like, okay, going back to medical, because medical is what I know from a licensing perspective. Like I have my national boards, my C that I took my NBCOT test, you know, that whole thing where I'm uneducated and shit. Sorry, I have to laugh because some of this shit is just fucking ridiculous. But with that, every state has its own licensing. I can do things as an OTA in Wisconsin that I am not allowed to do as an OTA in Georgia. Specifically, certain modalities like paraffin wax. I can use it in Wisconsin. I have to get trained on each individual modality in Georgia. So there's differences of individual rules for each profession in each state.
Yeah. And that makes sense. California rules and procedures probably most likely going to be different from Utah's rules and procedures in criminal court and sports in
where
general.
you can be a lawyer.
Yep.
You can have graduated law school. You can be a very educated lawyer in your state.
Yeah.
You can be a great lawyer in your state. However, when you are pro hoc vice in another state, you are back to square one and a newbie, because that state has rules of professional conduct that aren't the same as your state. I mean, some obviously overlap, but there are some that are different. There's rules of evidence that may be different. There's rules of civil procedure that are different.
You would think next everybody, hey, co-counsel, this is how it works in Utah.
And it's one of them situations where you can be a great lawyer in California, you can come to Utah and make a complete ass out of yourself because you might not be versed in rules of evidence, rules of professional conduct that are specific to Utah.
Yeah.
Just broken pasta. Something's broken.
So if you file something that relates to issues that the rule says should not be commented upon extrajudicially, you're saying that that opens the door. The mere filing of something opens the door to making any extrajudicial statement that you want about that subject matter?
No, that's not what I'm trying to do. No.
Okay, so why don't we let Mr. McBride ask you about that interpretation? Because I'm going to move on to my next question.
Basically, I got my ass handed to me and I don't have another question because I just got embarrassed. I'm going to move on. Let me interpret that for you, Novak. I got this. I look at the prosecutor's table. I'm going to let somebody else ask you that question because I did. Hey, Flash fan. Soft old man, how are you? I'm digging this Flash fan fellow. Do you have a YouTube channel? He does not, but he should. He does, however, have a Discord. If I don't stutter and I can actually talk, he does have a Discord server called Court Watch, where he does trials every day. He is currently going through Menendez stuff. He has gone through some stuff in Georgia. Oh, I can see his face. Faust.
Yeah, he was in court recently. He didn't want to tell about it, I don't think, but his attorney.
Yes. And Snipe Hunter seconds me. He doesn't, but he should. But we have to crowd. Okay. So in Flash Fan's defense, he's using an iPad.
Yeah.
And YouTube doesn't allow you to stream, and StreamYard doesn't really like iPads.
I can only be on here as a guest, so I couldn't be. I would have to have somebody create a channel, and they would have to be posted.
What we would have to do is we would have to do a crowdfunding stream where we set up a give, send, go for Flash Fan to get him a simple laptop that he could use for a simple laptop, a simple refurbished microphone setup where he could actually start a channel. Because I think,
no, I don't need all that stuff.
Well, you know what I mean. You can get a prefab microphone on YouTube or on Amazon. You can get a cheap laptop from Walmart that allows you just enough to stream. That's all you really need to start out.
Yeah.
But it does cost money. So, yeah. It's one of those situations where we will, because people start up give, send, goes and GoFundMes to like take their dog to the vet. So like, we could, pay to stop me. Yeah. See, I can't grift for myself, but I can grift for everybody else because I think other people are worth it. And when I know people are worth it and my friends I think are worth it, I will grift the hell out of that shit. Because Flash Fan is one of the people who sends me, hey, have you seen this case? Hey, here's this hearing, just in case you haven't seen it. Hey, here's this. Saves me time, effort, headaches, is a great help, and this channel once again would not be where it is without my friend and my little brother Flash Fan. He is not actually my little brother obviously. However, I claim him as my little brother.
Try to make me get emotional on stream. I'm a man. I will not get emotional.
Shut up. Men get emotional too. Shut up. Yes. Plus, people could donate very usable items that sit in drawers. Yes, I have a keyboard you could use. Yeah, didn't let my first go. You know what I was offering.
I got a half chewed up keyboard in
I
here.
feel like my kitchen sink is running. We're gonna restart this because I had fun making fun of Novak, but I feel like I have to go see what my toddler is doing. Be right back.
Yep.
Joys of being a 3-year-old mom. When you hear stuff that you really shouldn't be hearing, you gotta go.
Why don't you turn, please, to Exhibit 1?
Like watching the dog, speaking of which.
And this is not an email from you, but it is one that you are copied on. It's actually a couple of emails and a letter all together in Exhibit 1. Do you see all that?
Yes.
Okay. So first, let me ask you if you are familiar with the first 2 pages of Exhibit 1, which are a string of emails that basically start with Mr. McBride writing to, I mean, the email addresses are redacted. This is how we received it. But let's just say writing to many people who are in government or in law enforcement. Would you agree with that?
Yes.
All right. And you're copied on that email as well, right?
Yes.
And then if you go to the 3rd page of this exhibit, and I should back up, Mr. McBride's original email to the law enforcement and government individuals I was referring to was September 15th of 2025, right?
Correct.
Which is actually the day before the court entered its first publicity order, correct?
Correct.
So if we go to the 3rd page of this exhibit, this is an email from you, also a couple days before the court entered its September 16th, 2025 order. And you're writing to, well, are you familiar with this email?
Yes.
All right. And now let me ask you to look at pages 4 and 5. Those are the last 2 pages, Your Honor, of this exhibit. This is a letter written by Mr. McBride. Do you see that?
Yes.
Dated also September 12th, 2025.
Yes.
You're familiar with that one as well?
Yes.
All right. So, Your Honor, I would ask the court to receive into evidence, subject to any redaction which Mr. McBride thinks is necessary of emails, although I think they've all been redacted before produced to us. All 5 pages we're asking the court to receive into evidence.
No objection.
All right, and this is state defense exhibit 1 with no objection from the state will be admitted.
Okay, so let's go back to page 1, Mr. Ballard. In his email, well, Mr. Ballard, you know generally who the people are who this email was sent to, right? The names behind the redactions?
Generally, yes.
Can I just refer to them as law enforcement partners?
Yes. I think that's accurate.
Some have email addresses that are local law enforcement agencies, including Utah County, correct?
Correct.
Fork,
Yes.
Utah Valley University, not a law enforcement entity, of course, but they have a law enforcement department at UVU.
Correct.
And at least a couple recipients are with the FBI, right?
Correct.
All right. And so in this email, Mr. McBride says at the bottom, quoting Rule 3.6, there are certain subjects that are more likely than not to have a material prejudice effect on a proceeding, particularly when they refer to a criminal matter that could result in incarceration. You see that?
Yes.
And then he says these subjects relate to, and then on the next page, I want to draw your attention to Roman numeral 3, the performance or results of any examination or test, or the refusal or failure of a person to submit to an examination or test, or the identity or nature of physical evidence expected to be presented. Do you see that?
Yes.
Do you agree with Mr. McBride's assessment that Rule 3.6 prohibits extrajudicial statements about that topic or those topics?
Yes, this email represents our efforts even before the court issued its order to recognize that we had obligations under Rule 3.6 and that we were careful to abide by those obligations.
You were careful to inform law enforcement partners in the email of their obligations, correct?
Yes.
And then item 4, Roman numeral 4, also on page 2 of the exhibit, says, as another example of subjects that are more likely than not to have material prejudicial effect on a proceeding, any opinion as to the guilt or innocence of a defendant or suspect in a criminal case or proceeding that could result in incarceration.
Yes.
He's going on and on and on. It's a foundation, but I'm wondering where he's going with this.
All right, now if we could turn to page 3 of the exhibit. This is an email from you to what I will describe, unless you disagree with me, as law enforcement partners, which is the following page from Mr. McBride, dated September 12th.
That's correct.
And
So
that letter,
2 days after the incident.
also, the letter is addressed to all personnel likely to make media statements regarding the Charlie Kirk case.
That's correct.
And the letter says, just below that, the Utah County Attorney's Office has an ethical obligation to, quote, exercise reasonable care to prevent investigators, law enforcement personnel, close quote, and others from making public comments which, quote, have a substantial likelihood of materially prejudicing, close quote, the trial process. That's what Mr. McBride wrote in the letter that you forwarded to chiefs and others, correct?
Correct.
And Mr. McBride's letter also says that prosecutors have a special duty to ensure that law enforcement and other officials adhere to these rules, citing Rule 3.8E, correct?
That's correct.
And then Mr. McBride identifies statements that should be avoided. Or I should say, yes, statements that should be avoided. Do you see that? Statements should avoid the following, colon?
Yes.
All right. And there are 4 bulleted items there, right?
Yes.
One of them, the third one, is opinions about the defendant's guilt or proper punishment. You agree with that?
Correct.
And do you agree with Mr. McBride?
Okay, I have a observation. He's laying a foundation. It seems like, hey, you said that they should avoid all of this, and then you said this is where I think he's going.
Yeah,
That's what I do as a woman.
Yeah, this motion that they're arguing that, I guess, I don't know if whatever the rule said, maybe the rule or his interpretation or whatever said that you can't make statements. They're saying that the court signed the gag order saying that they couldn't talk about the case, and they're saying that the state, Chris Ballard and I guess Jeff Gray, the elected Utah County District Attorney, made statements to the media, and that's what they're saying. They should be held in contempt for violating that gag order that the court signed or ordered. It
is just one of those situations where I feel like he's laying a foundation that's going to have nothing to do with what he's going to ask. And King Bob, thanks for the $2 super chat. Did you hear Michelle Obama's man? Oh my god. So it's UFC at the UFC on Flag Day. And so y'all, okay, sidebar controversy. People that hate Trump and have TDS say that he does this shit for his birthday. Well, his birthday just happens to be Flag Day. So like it's Flag Day just so happens to be his birthday. So like if y'all stop looking too deep into shit. But one of the UFC fighters was like, thanks to the White House for, I can't remember after his like, when fighters win and they do a victory like speech.
Yeah.
And
pre-victory.
His last words were, oh, by the way, Michelle Obama's a man. I'm like, did you just say that? I was like, oh my god. I can't help but laugh at the absurdity of that shit. Like, if I were Michelle Obama, no matter if that ends up being true or not, I'm not saying because I don't know and I have no desire to know. However, it's been said so many times by so many people. It's like, just laugh at it. Like,
as long as Brock doesn't pull a Will Smith.
It's one of those things like you just have to laugh at it, at the absurdity at this point that it was said. It was said at the location that it was said. Like, oh my god. Like, just would I have said it? No. But will I laugh at the fact that it was said anyway? Like, I was like, I watched it after after I got done streaming. I was trying to watch it while I was going to sleep, and I heard it, and it was just like, I honestly just like, yeah, it was yeah. Hey, dear most, I hope your hubby's doctor visit went great. Dude won his fight, then blurted that out. It was hilarious in the moment. Repercussions to come. Yeah, there'll probably be some repercussions, but I don't think people care at this point. So we're gonna get back into
He
this.
gonna get slapped by Barack Obama.
I'm just
Have an ethical obligation to both avoid those themselves and to take special care to make sure that law enforcement personnel and others refrain from making such comments?
Yes.
And then the other statement that should be avoided are any other statements which could risk violating the defendant's right to a fair trial.
Correct.
And would you agree with me that the any other statements phrase by Mr. McBride in this letter would include the more specific prohibition on extrajudicial statements about the performance or results of examinations?
Yes.
Tests, yes? I'm sorry for interrupting you. The answer is yes.
Correct. Yes.
All right, I'm now going to turn your attention, please, to Exhibit 3. Tell me if you've seen it before, if you recognize it.
Yes. I recognize this.
Okay.
and if you notice a little leg or a little like skip ahead, it's
Do you
because
recognize this as an article
am skipping.
published online by TMZ concerning this matter in which you are quoted?
Okay, Elaine.
TMZ.
Elaine.
My first question is,
Sorry, when I hear TMZ, all I think about is Emily D. Baker going, Elaine, Elaine. I mean, that's my impression. It's a really bad impression, so nobody tell Emily D. Baker that it's an impression of her saying Elaine. It's really bad. But all I hear is her going, Elaine, Elaine, Elaine. And I'm like, okay. Oh my god. Oh, flashback to Johnny Depp.
I still need to watch that full case.
how is it that you came to be quoted? Well, actually, let me ask you this question. If you look on the second page of this exhibit, down toward the bottom, underneath the image of a black screen, the paragraph starts, Attorney Christopher Ballard tells us, comma, quote, and then there's a very lengthy, well, there's a few sentences in quotes. Do you see that?
Yes, I do.
Okay. Did you tell TMZ that?
Yes, I did.
All right. So my question is, was that over the telephone? Was it an email? Was it a face-to-face meeting? How is it that your quote was communicated to a representative, a media representative of TMZ?
It was a telephone conversation.
And did you only have one telephone conversation with TMZ?
Yes.
And how was it that the telephone conversation came to be set up?
After the defense filed its motion to continue the preliminary hearing, there was a statement in that motion that garnered quite a bit of media attention.
So basically, you started it. You made controversial statements that I needed to clarify. I feel like defense attorneys do this shit all the time. And honestly, I don't blame them 100% because it introduces that doubt into people's mind. But you make a statement and you say something in that statement or in that motion that the other side can't respond to.
Yeah.
And or you know that the other side is not going to respond, so you make comments on like podcasts and shit that like you know that the other person is not going to talk about because they have integrity and you don't. And then all of a sudden they respond and you play victim. That's what Novak's doing.
It also can be used as a strategic, that word, tactic.
Strategy.
Yeah. To basically, there's no question that you're not going to find any jurors, no matter what county this case is in. They talking about maybe changing venue at some point. There's not going to be a jury, potential jury you're going to find that don't know this case. So put that stuff out there, gets people thinking like, maybe this guy is innocent or maybe they have something. But when they do this thing, I get falls short.
So it's just one of those like the defense did it knowing or thinking that the prosecution wouldn't defend themselves or explain things to the media to clarify situations, because like when we went over the bullet analysis and it was like I brought out I didn't have a 30-06 bullet, but I had a a 300 blackout, and a 338 Lapua. But when we were talking about the bullet fragments, I showed those two, freedom seeds just to show you when we were talking about microscopic, when we are talking about microscopic levels here. So it's one of those showing when you clarify things, it sounds good when they say, oh, the bullets didn't match, but then you logic it out.
I think this is talked about in testimony too.
And when you logic things out, and then it's oh, that headline really doesn't make sense. That's what I feel like the defense said something in their motion or their statements that sounded controversial and like a hot button issue. And then the prosecution went on to clarify their comments. And now the defense is playing victim. You weren't supposed to talk about it. You know what I mean?
Yeah.
It's like it's like the typical Darvo, just the courtroom version. It's like the narcissist. We're looking at a narcissist right here, narcissistic behavior. When you say something, you expect the other side not to respond, and when they do, you play victim. Novak is currently playing the victim role in this situation. I'm assuming that this will be hold on one second. I have to return a phone call.
Mm-hmm.
Or thing.
Yeah, this case is crazy, y'all. This gonna be one of those cases.
All right, let's get back into it.
I came to be aware of that media attention and the headlines that statement had generated. And there were quite a few media inquiries to our office based on the statement in the defense's pleading and the media stories that statement had generated. TMZ was one of the media entities that called our office. I received an email from someone else in the office, I can't remember who it was exactly, that said, I got a call. They received a voicemail from a reporter at TMZ. That employee in our office forwarded me that voicemail, and the voicemail just basically said, we have some questions about these issues.
All this DNA
statement in the motion to continue generated. And so I returned the phone call.
8 to 12 weeks.
Before you returned the phone call, did you have any discussions in your office concerning whether there should be extrajudicial statements about the issues that you're describing?
Yes.
Yes, but we are also just responding to shit that you put out in the fucking media yourself.
Okay. And did you discuss that with Mr. Gray before you returned that phone call?
Yes.
Did you discuss that with Mr. McBride before you returned that phone call?
No.
Did you discuss that with anybody other than Mr. Gray before you returned the phone call?
I know for certain that Mr. Gray and I discussed it. I have a vague memory that Mr. Grunander was involved at some point. But my memory is that Mr. Grunander was out of the office the day that all of this was breaking. And so he may have just been informed, brought into the loop after the fact by telephone. But I do recall that very early in the morning, I think it was of March 31st, because my memory is that the media story that launched all of this interest was posted, I think, late Monday afternoon, Mountain Time. And so by Tuesday morning, I was getting a lot of media inquiries. And I think Mr. Gray had also, my memory is that Mr. Gray received a phone call from Turning Point USA asking us if there was any merit to these media stories. And that's when Mr. Gray came into my office. My recollection, it was first thing Tuesday morning, and we discussed these.
He's getting so uncomfortable.
So Turning Point USA reached out to me.
It's one of those things body language. So I'm not a huge believer at all in this is how you can tell someone's lying. This is how you can tell someone's lying. However, when Novak, we've seen enough of him to know what he does when he's comfortable. He does a lot of this, standing, holding both hands.
Yeah.
He's confident. This, with him holding and rocking back and forth, is new. He only does that when he's uncomfortable. He only does that when he's being challenged and he's guarding himself.
Yeah.
He is protecting his internal organs. Not to say that the prosecutor is going to do anything, because that's not what that means. But like, when you protect yourself, what do? We put our hands in front of our reproductive organs. We cross and, close ourselves off. That's what he's doing. He's never done that.
I guess he probably just worried because, one, he's cross-examined and technically redirect, but it's cross-examination because this is adverse witness to him. But he's cross-examining the prosecutor, who is a Utah licensed attorney, unlike himself.
But it's one of, that's the thing too. But it's one of those things of, I don't believe in like body language, like you can tell someone's lying. However, there is think about generalizations in life. You walk into a room, you can tell when someone's happy. You can tell when someone's sad. You can tell when someone's angry. If someone is always doing a certain body language when they're in their comfort zone, and then all of a sudden they start doing something else, they're not comfortable. Something changed. He's being pushed back on in a way that I think he thought he had the upper hand. And this is where like California people drive me nuts. And I'm sorry if you're from California. I don't mean to generalize, but like lawyers who think they're the smartest people in the room, and then you're in a room full of lawyers and you still think you're the smartest person in the room. That's why I think he's Mark Diller, the West Coast version of Mark Diller. He thinks he's the smartest person in the room full of lawyers. Still thinks he's the smartest person in the room. And it's like something changed when all of a sudden
It's not going in his favor. He's like, oh, I want to respect.
Yeah, and all of a sudden he goes from holding on with both hands and being tall and confident to this. Like it's just pay attention to what people do when they are confident and they're in their comfort zone, and you can tell when they're confident when you can see what they're saying, and they believe what they're saying. And then when something changes, it's noticeable, and that was noticeable.
To Mr. Gray, and Mr. Gray came to speak with you all about the same time that you received this forwarded voicemail from a TMZ reporter.
The voicemail from TMZ came later in the day. It was before noon, but it was a busy morning. There were a lot of media inquiries that were coming in that morning. And I know Mr. Gray and I
we can only see his backside.
First thing Tuesday morning to discuss.
I don't want to see those eyes.
And you and Mr. Gray had a conversation which led to a decision to return the phone call and make a statement to TMZ?
I did not discuss every media inquiry with Mr. Gray. I think I just generally told him, he brought up the issue that there were concerning media reports out there, potentially prejudicial media reports. I confirmed to him that I was getting media inquiries, and we generally discussed whether it would be appropriate to respond to those.
So did Mr. Gray know that you were going to call TMZ back?
No, I didn't discuss with him every media inquiry. Our conversation was general. We reviewed the requirements of Rule 3.6. I don't recall that we actually pulled the rule and read it, but we were familiar with the rule, and it's what it prohibits and what it allows. And we believed that under, I think it's subsection C, and also under the court's order, which specifically references subsection C of the rule, that we could respond, that this was potentially prejudicial media stories that we did not generate, and that the rule allowed us to be able to respond to those.
Were you aware of any extrajudicial statements by the defense which generated that media coverage?
No, and nor does the rule require that.
Well, that's your legal interpretation of the rule, right?
No, that's not my legal
I
interpretation.
mean, you were here when Mr. McBride argued to this court at the last in-person hearing that as long as there's some negative coverage out there, regardless of the source, that the state has leave to make extrajudicial statements on the same subject matter.
I heard that argument, yes.
All right. And that's a legal argument, right?
Yes.
Okay. All right. So here's my question. The information in the TMZ article, which purports to quote you on the second page of Exhibit 3,
Okay.
is that an accurate quote? Is that what you
Yes.
said?
Yes, it's accurate. I don't know that it's word for word for what I said, but it did not.
It's
It
TMZ. I
accurately
guarantee you it's not word
captures,
for word.
My statements to the reporter.
Mr. Novak, and I don't mean to interrupt you, but are you intending to admit exhibit number 3?
Yes. Now that Mr. Ballard has said it's an accurate
Okay.
recitation of what he told TMZ, I would now ask the court to receive it into evidence.
No objection.
All right.
What your views are on bullet fragment analysis, correct?
Yeah, I'm just saying, AP, like when you can see when he's confident in asking the questions, both hands are on the lectern. And when he's getting an answer that he's comfortable with and what he wants to hear, he holds both hands. When he all of a sudden gets pushback or it's something that he doesn't want to hear, shit changes. He crosses his arms, his posture changes. It's noticeable. It's just, you know. But I'm not like you look up and left and you're lying. It's you always do this when you're confident in what you're saying. And then all of a sudden something changes. You're not confident in what you're hearing, or what you're hearing is not something that you wanted to hear. And now you're uncomfortable, something, or you're mad, or, you know, your emotion changed, something changed. And it's just interesting to pay attention to the changes in someone's body language. It doesn't mean it means anything in particular. However, it's interesting to pay attention to changes.
I wouldn't
That's all
characterize
I'm
it as
saying.
my views, although I guess you could say it's my understanding in general of how bullet fragment analysis works.
And you're also commenting on the contents of the results of the testing when you say the fragment didn't contain enough detail for the examiner to say one way or the other. That's you basically commenting on the content of the results of the examination as you understand, correct?
What I'm commenting, if you look at the first word, I say generally, and generally when you have an inconclusive result, the reason that you get that inconclusive result is you do not have enough detail.
Okay, but now you're again testifying about your understanding of bullet fragment analysis. And I'm just asking you, if you told this reporter, it's an extrajudicial statement, what?
I'm not gonna lie. Damn it. I actually agreed with the way Novak presented that. Just saying.
Your views are on bullet fragment analysis, and you're reiterating
Good points in here sometimes.
the conclusions in a report about
Even a
bullet
broken
fragment.
clock is right twice a day.
Objection. The statement speaks for itself.
Would you like to respond to that objection, Mr. Novak?
Well, I don't think that the answer to the last question was responsive, so I was trying to go back to the question. I guess I could have moved the court to strike the answer as non-responsive.
I'll sustain the
I
objection.
could have, but I didn't.
And then in the same quote, Mr. Bauer,
I could have, but I didn't. But I'm gonna blame the defense or the prosecution instead of realizing that I fucked up and didn't strike.
Oh, this trial gonna be brutal.
Oh my god. Oh, I need to take vacation for this.
And that's also why I'm predicting that this trial gonna be long also, because this dude, if he gets convicted, there's a penalty phase that's gonna have to take place.
I might have to do some like middle of the night streams for this, like 2 to 4 a.m. like insomnia streams. Hey Bunsen, how are you? Good to see you. Yeah, this is the change matters to the questioner, not the audience. Good point.
after talking about bullet fragment analysis, you say there's just not enough there to determine whether the bullet was fired by a particular firearm. That's you telling a reporter what you believe the forensic testimony in a proceeding will be.
No, what I'm
No.
referring to is generally the types of circumstances that could produce an inconclusive result.
Okay, but you say
He is not making, I get where Novak is coming with this.
Yeah.
I do. But I think Novak is trying to put words in his mouth that he didn't say.
And I even agreed when they argued a couple hearings ago that they needed an evidentiary hearing on it, because the state, like, well, the defense says stuff that we felt we need to clear up. I'm like, well, you're not supposed to try your case in the media. You're supposed to try in the courtroom. So, but then we got to the evidentiary hearing, I'm like, you got him lost me. I would agree.
I see where Novak is going with like the basic premise.
Yeah.
However, the execution, okay. I give him a 9 out of 10 for the purpose. The execution is like a 2 out of 10.
They should have maybe had the
I'm not a
Utah
lawyer.
attorney handle this, because I don't think he knows the Utah rules.
Well, it's not even that. It's he's not, I don't believe he's trying to make it sound like he made an extrajudicial statement. I don't think that he did, because he did not, and I'm not a lawyer, so I might be wrong. I'm open to being wrong about the specifics of an extrajudicial statement in Utah specifically. However, he is not making a legal conclusion based on what the reports had said. He is responding to a question from the media about, hey, the bullets did not match.
Yeah.
No, it's not that the bullets did not match. An inconclusive result can be from not having enough information or enough, because remember, so, okay, here, definitely not the same size caliber, but this is from my side check. This is a 45. Look how small the projectile is there. So when that fragments through a human, that's going to be a very, very tiny, tiny piece. This is not CSI. This is not NCIS. This is not TV or the movies where you can 100% say all the time within an hour that this bullet came from this rifle at this. That's not how this shit works. So to say that it's inconclusive does not automatically mean that it didn't come from that rifle.
It also, if it's
You might have
inconclusive,
too small of a freaking piece.
if I'm the defense and the state is saying it's inconclusive, I'm jumping for joy because that could work in your favor.
Buffed old man, this is the prosecutor. This witness is the prosecutor.
Yep.
Uh,
We have a Baldwin
So,
type situation. I love when prosecutors on the stand or defense attorney get called to the stand in these type hearings because it gives them opportunity to argue back. You know they're gonna argue back and forth.
Yeah. So this was before the official, and one of the other things is this was before the official order from the court came out.
Yep.
However, after certain things were said in the media was calling their office, and even Turning Point USA had reached out to their office and said, hey, is there any validity to these reports? So I understand not talking to the media, and I understand where you're coming from, but at a certain point, when it's this high profile of a case, there are certain issues that I feel like need to be quashed. Otherwise, they could. The defense is so worried about him not getting a fair trial.
Yeah, they say that. They say that in every file. Like, it impacts Mr. Robinson's right to a fair and impartial trial. Like, what are you talking about?
Well, think about this for a second. And this is something that I really don't bring up very often because I generally hate the prosecution. Like I go into every trial hating the prosecution because they have the burden of proof.
Yeah.
However, if just like the defense is worried about headlines and media coverage giving the defense or the defendant an unfair trial, if there are headlines out there saying the bullets don't match,
Yep.
then you automatically have, if the bullets don't match, he can't be guilty no matter what other evidence they say.
Yeah, it works in their favor.
I see the need to correct the record on both sides to get a fair trial, because if you are tainting the jury pool one way, you could also taint it the other way.
Yep.
So in the interest of fairness, that is true.
Change the venue motion. I'm sure it's probably gonna come after the preliminary hearing.
Not being fired into ballistic gel, a lot of bone causes issues with deformation and fragmentation of a projectile. It shouldn't be hard to understand, actually. Yeah, and honestly, like, look how tiny. Like, I mean, this is a 45, obviously not the same. For those in the chat or those in the comment section who are replay crew who don't understand that I don't have a 30-06. However, I have a 338 Lapua, a 300 Blackout, and a 5.56. Like, I have things that are in the same ballpark. Some bigger, some smaller. we're in the same family. We're cousins. We're just not, this is my side chick. This is what I carry when I leave my house. So this is what I carry when I go to, like, this is what's locked in this drawer right now. So this is what's this is why I tell people not to knock on my door at 1 o'clock in the morning.
You know, people, we had one of those ones knocked on the door, tell me, can I use the bathroom? I'm like, there's a gas station around the corner. You better walk there.
Yeah, 300 blackout would be the closest I have, but I also brought the 338 Lapua ammo to show a comparison. Mr. Squid took them back. I had them sitting on my desk for weeks, and Mr. Squid sat at my computer and took them back. It's, because technically the 338 Lapua is his. I just like to claim it as mine because it's cool as hell and I love it.
Okay, I thought you was taking it back like she going
No, the 300 blackout is mine.
Oh.
That's my baby. The 300 blackout is mine. The AR is his. The 45, the 9mm mine. He has a D365 that he lost in a boating accident. I have Benelli. My baby is my Benelli. That's my baby. That's the most expensive thing I've ever bought in my life. Besides a car and a baby. Yeah, what we don't have would be easier to say. That's true too. Yeah. The 300 blackout is mine though. It's my
people would think twice about trying to come
baby.
People would think twice about trying to come into your house.
Just saying. The 300 black or the Lapua, if you stand it on its end, it comes up to about here. Like, it's huge. It's huge. All right, we're gonna get into this.
There's just not enough there to determine whether the bullet was fired by a particular firearm. You're referring to the fragments recovered, correct?
No. What I'm referring to, you got to read that in context with the first sentence.
I'd like to read it in context of the next sentence, which talks about the evidence, in your view, being
And of course he
sufficient
cuts
to
him
prove
off.
that Mr. Robinson committed the murder. You're commenting on the bullet, and then you're commenting on your opinion about the sufficiency of the evidence.
So here's how the quotes came about. The reporter first asked me about these, the media reports and the misleading statement in the defense's motion.
Oh, the misleading statement in the defense's motion. Tell me you weren't prepared for this argument without telling me. Or you were prepared for this argument without telling me. Or, I'm here for these fireworks, and this is what I like about it.
I hope they tell. I know some of these cases they start off talking about in the pretrial hearings, and they stop at that. Well, I hope they talk about every single pretrial hearing, unless the case is sensitive stuff, and the hearing has to be closed. Because
I think everything should be televised. If I'm allowed to walk into that courtroom and sit in the gallery and watch it, it should be televised.
yeah. And I feel like with the way the media been fighting on, with the defense saying we want the media out, I have a feeling they're going, just despite them, they're going to file every time to get to every hearing this televised.
My brother-in-law has a Kentucky long rifle. That thing is heavy as hell. But it's cool. It's a flint loader. It's from Civil War era. It is cool as hell, but it's heavy.
That the bullet that was recovered did not match the rifle. And I responded to that and said, generally, when you have an inconclusive result, it can be caused by these general types of circumstances. The
General.
reporter then asked me, well, do you still have a case? And focused specifically on whether the additional media reports out there that the
Mama duty.
supposed inability to match the bullet to the gun was a bombshell finding for our case, and that it completely undermined the foundation of our case. So that next statement was responding specifically to that question as to how does this specific, how do these specific reports and the representation in the defense's motion, how does that affect our ability to proceed with this case?
I'm going to move to strike portions of the statement which mischaracterize the defense pleading as misleading. This court has never made such a finding. And we had argument about Mr. McBride's interpretation of what is and is not exculpatory evidence. I think we all remember the court's comments on that. So I think without trying to parse it too much, I just asked the court to strike the portion of the statement which characterizes the defense pleading as misleading.
Bro, there's no jury
I
present.
think the court can take this statement, the testimony, for the value it deems appropriate. Testimony is asking about Mr. Ballard's perceptions, and that's what he's testified about. The statement in defense counsel's pleading is a matter of public record, and what we're really talking about here are the reports that were generated from that statement. So I would ask the court not to strike it, but to take it for the value it sees appropriate.
All right. The court recognizes first that it has not made a finding that the defense's what defense presented in their motion was misleading, but also notes that this is the personal opinion of Mr. Ballard and makes that distinction. Thank you.
Thank you, Your Honor. So, Mr. Ballard, what you're saying is that you had, how long was the conversation with the TMZ reporter?
I think it was less than 10 minutes. It might have been just about 5 minutes.
And so the quote is a compilation of your statements over the course of the 5 or 10 minutes, right?
Right. And strictly in response to the questions that the reporter was asking me.
But you certainly had the discretion to not answer the questions, right?
Yes.
You could have said, I can't comment on specific evidence or what I think the quantum of evidence is, right? You could have said that.
Yes. And I didn't comment on any specific
He
evidence.
did.
Well, when you refer to the bullet, you're not talking about the bullet fragment removed from Mr. Kirk's body?
No, I'm talking about general circumstances that can produce and
How the English language works. You say duh. You don't say a. You don't say bullet fragment. I don't get what he's trying. Okay.
I get he's trying. I
he
feel
making
like
me
this is
sound
like the
stupid.
lawyer version of entrapment. Well, like you said this. No, I said the general circumstances. I never specified which one applied here. I see where the prosecutor is coming from.
Yeah.
I really do. And that's where, like, this is where I hate. I'm like, because I generally want to side with the defense in anything.
Me too. I really want to like the defense attorney in this case, but they're making it very hard.
Put this right here. All things being equal, TMZ would not be my preferred news source to rely on. Yeah. And I would not do the only way I would ever do anything with TMZ is if it's live. And the reason I say this is because when it's live, they can't cut anything I say.
Yeah. They
When
can't.
it's a phone call, they can edit quotes. When it's a recorded video, they can edit things and not say who you are or cut, make jump cuts. When it's live, you can't edit anything. That's the only way I would ever talk to any mainstream media, to be honest with you. But I see this is like the legal version of entrapment because they're literally like, Novak, literally, well, you said that this. No, I was stating generalizations because you mischaracterized the evidence. And I was just saying generalizations. Any number of these can cause an inconclusive result. I never specified which one specifically I thought related to this case. I'm just stating here. I absolutely love Flash's laugh. Even better. So I love having Flash on. And thanks for reminding me that I invited you on today. I totally forgot.
Yeah,
And
usually.
I would have
Okay,
forgotten.
let me see. Usually, I don't ask. Like I said, I feel that's inappropriate. But hey, can I get a link? But I know. So you said last week. Let me make sure so I know to plan accordingly with court one.
Oh my god, I did that with Just Jay the other day. I asked him to send me a link in chat, and I was like, "Wow, I understand why I hate this so much, and I hate doing this." And I was like, "I feel like a pretentious asshole."
I
And I'm
mean,
like,
it works for people, but for me, I guess it's
It
just
doesn't. It
outrageous.
always annoys me when it happens, and I never like try to push my way onto people's streams. That's one of the reasons I don't collaborate with people. One, I don't really play well with others, so I've been told. However, secondly, I don't ever like want to be a burden to people or bother people, so I never like ask. If people ask me to be on their streams, sure, I will come on, but I never like, hey, are you going to send me a link to your stream today?
That's usually what I do. When people ask, I'm like, yeah, sure.
So if you see me on people's streams, 99.99% of the time, it's because they asked me. I never ask them.
I'm
because
just
that's
waiting
your
for Emily D.
personality.
Baker to ask you to join. Nah, she don't need to collab with people that's of her YouTube that has her numbers. So
It's just one of those situations where like I talked about having you on for this and then totally forgot about it. So I'm glad you reminded me because I totally zoned.
that felt something. I'm like, why don't I feel
Yeah,
like
Flashman, you need to show up more often. Squiz brain forgets. I do. I do.
it's not that I think she'd be offended. It's just wow, Ray, you don't.
It's not his personality, but it's not mine either. That's why we get along so well.
Like I said, I just feel like that's inappropriate when I ask like, hey, can I be on certain? Nah, that's not my stuff.
All right. Well, let's get back into this because we're at 2 hours and 20 minutes. We got to keep trucking along.
And they
Would
do
you
ask for a
agree
remedy
with me
here.
that
I'm
one
like,
of the reasons
wow,
why
I can't wait to
extrajudicial
do
statements in many circumstances, and we assert
You can
in
tell
these
he's
are prohibited,
confident
is for
again.
exactly that reason.
that.
That
Yeah,
reporters may,
he
for
moved
either
it.
innocent or other reasons, take statements out of context or misconstrue things, and there's nothing you can do about it. Because once it's published, right?
Once something's published, it's published, yes.
Once it's published, it becomes public
Why don't we
record.
turn to Exhibit
No.
4, please? Okay. And did you have a separate conversation with a reporter from USA Today?
Yes, that was an email conversation.
So a reporter from USA Today wrote you an email and you responded.
Correct.
Did you preview your response with Mr. Gray?
No, again, we just had a general conversation about whether Rule 3.6 allowed us to respond to the prejudicial media stories that were circulating. And we
Prejudice. Oh, you know, like you keep talking about the media and being prejudicial against your client. Well, guess what? Street works both ways. This is not a one-way street, asshole.
I really dislike when the attorneys and judges be like, well, I'm trying to, but the reason why we don't want cameras to read, we're not allowing cameras is because, but we want to protect the defendant's right to a fair trial. The Carmelo Anthony judge came out last week saying that's why I didn't allow camera because I wanted to protect this right to a fair trial. Like, come on, man, when do y'all using that excuse?
It's one of those situations where I get wanting to protect the defendant's right to a fair trial because today it's them, tomorrow it's us. However, you also have to protect the prosecution's right to put on a fair trial.
Yeah.
You can't taint the jury pool in the other way. For example, like in the Carmelo Anthony, people saying I could never convict or I could never vote to convict.
Unfortunately, that's with people my coaching. Like I wish we weren't, but that's
And that
people bring are made to work because
but it's not just a certain race, gender, whatever.
yeah,
People are like that.
yeah,
People are just like that in general. However, it's one of those situations of you also have to put on give the prosecution the right to put on a fair opportunity to present their trial. Like the shit works both ways.
yeah.
Like you can't have it one way and not give the prosecution a fair shot too. Yeah. But Squid needs a little push, a little memory nudge. Yeah. Yes, because a lot of shit like that I don't write down. I write down what I'm going to stream on certain days to like make sure I do thumbnails because I'm trying to get stuff out ahead of time. Or at least I'm trying to have a plan so that morning I can make my thumbnail and get the shit out early. It actually might be better now that I don't have to do bedtime every night. So Mr. Squid used to have to go to bed at like 7 o'clock because he would wake up at the absolute butt crack of dawn. Now he has normal people hours and he is only driving 20 minutes to work instead of an hour.
Oof.
So he works normal people hours. So he gets home later, but he goes to work later and he goes to sleep later. So he will go to sleep after the little goes to sleep. He was going to sleep around 7:30. She goes to sleep around 9. So like I was having to do bedtime every night, which made work hard. So
Yeah, I remember you used to do night court. You like, yeah, I can't do that no more. You do night court.
my
Really?
daughter is screaming for some reason, so I'm gonna play this and go see what she wants.
Yep.
Oh, I gave her chips and she needs more water. Be right back.
Mr. Gray and I agreed that it would be appropriate to respond under subsection C, and he left it to me to handle the responses.
Okay. So have you looked at the statements attributed to you in Exhibit 4?
Yes,
Are they accurate?
yes.
Did the court receive into evidence Exhibit 4?
Mr. McBride?
No objection.
Right, with no objection, defense exhibit 4 is admitted.
Thank you, Your Honor. The third page, Mr. Ballard, of Exhibit 4, which is a total of 3 pages, so it's the last page. There's some paragraphs down at the bottom of the third page. On your copy, are they highlighted in sort of purple?
Yes,
And is the court's copy highlighted in purple?
It is.
All right. So, Mr. Ballard, you see the statement, I'm sorry, the paragraph, the second to last paragraph that says Ballard confirmed.
yes,
Ballard confirmed the FBI and ATF are adding information to the initial reports, which prosecutors expect will include data supporting the initial conclusions. Do you see that?
yes,
All right. Is that an accurate recitation or summary of what you said in your email?
yes,
And so what you're telling this reporter is something that you understand the FBI and ATF will be doing in the future?
yes,
And you're also telling this reporter what you think those reports will conclude?
yes. This was in response to statements in the defense's motion to continue the preliminary hearing, where the defense represented that they did not have the supporting data, the underlying data that supported the initial conclusions. And the reporter asked me whether that had been produced, and I was responding that I anticipated that the FBI would produce the data that the defense was requesting.
Was that a matter of public record at that time, that the FBI and ATF were, quote, adding information to the initial reports?
I think so.
I don't believe it was a matter of public record, other than the defense had requested additional information, and I was confirming that we were facilitating.
Yeah, I'm
that
about to go
request.
back and
You're
look.
telling a reporter that we
Yeah.
had made a discovery request and that you were complying with it.
Correct.
But you were characterizing what the FBI and ATF were doing with their examination reports.
Also need to
Right,
read
no.
their
It says the
indictment.
FBI and ATF are adding
How many
information.
counts he got?
This is the hard part about this case. There is 600.
Yeah.
So this case is a year old, less than a year old. There is 601 documents.
And that's not even counting the stuff that was sealed.
Yeah, and that's like some of those are return of electronic notifications and
Yeah.
stuff like that.
That's just them.
Over-
That's just him great immediate request to televise. I think.
So there are 601 docket entries
Yeah.
for this case, and it is less than a year old.
Yeah.
Talk about peppering the court with paperwork. Like, talk about overloading the courts with papers. Like, the last one filed the 12th, which was last Friday, was the Utah Attorney General's notice of intent not to respond to the constitutional challenge. So probably because they don't need to, because they're like, it's not.
I think that has something to do with the Supreme Court stuff.
Yeah, that would be a waste of our time.
So that's probably dealing with the stay and the Utah Supreme Court, like, because apparently they got vacancies and stuff like that. So they saying that
Yeah.
they got a backlog that they're struggling with. So they probably like, yeah, nah.
Well, it's the Utah Attorney General's notice of intent that they're not going to respond to it. So the Utah Attorney General is probably like, this is going to go to the Utah Supreme Court. I'm not even going to waste our time responding to this because this case is already almost a year old and hasn't even had a
Preliminary.
preliminary hearing. What do you want stayed? What more can we do to make this easy for you?
Yeah, they just crying because the court ruled that, like, cameras can be allowed. So they're like, we want the Utah Supreme Court's opinion on it. What do they got to say?
This is what happens when entitled people don't get their way. They pepper the court with bullshit. And they whine and cry when they don't get their way.
Yeah.
What usually a preliminary hearing is a few weeks after the indictment.
Yeah, I want to say I need to look that up on Google. I'll look it up when you.
It's generally
I think it's like 30 days after the indictment or something or the other.
I mean, it's different for everybody, and I'm not a lawyer, so I'm not speaking, but in general, it is a month or two.
Yeah, there's usually like 1 or 2 hearings beforehand, like where we are we still on track? Yep, cool.
This is where, like, just admit that you have a shitty client with lots of really bad evidence, and you're trying to keep your client alive for as long as possible, and you have a bad case.
Yeah.
And just admit.
So far, this case has proceeded like it's in pre-trial. He hasn't even been bound over yet. They're filing motions that usually done to get ready for trial.
It's like, just admit that y'all have a shitty case, and the only people benefiting from this case is you and your pocketbook. The prosecutors aren't getting paid any more or any less. They're paid by the state. They're not paid by the case. They're not paid by the hour. They're on state salaries. Yes, they're pretty good salaries, I'm not going to lie. But they're not making any more or any less. They don't make any more money if he gets the death penalty or he doesn't.
Yeah.
Like, it is what it is. The only people who are benefiting from this case are the wallets of the defense attorneys.
Yeah. I want to see how much it is. I want to see if Google had information how much defenses cost.
Hey, Kitty Buck, what is Pro-Ox ceviche? I don't eat it. I'm obese and I'd never eat it. Appears to me that some defense lawyers are pretty good at what they do, and others are simply masters of stalling.
Oh yeah, there's definitely some good ones. We don't see them all. We don't see them often, but there are some good ones out there.
Jose Baez.
Yeah. Although a lot of people can't stand him because of you know who.
A lot of people can't stand him because of who he got acquitted. However, Exhibit A, he's a damn good attorney because of who he got acquitted. If he can get her acquitted.
And he only had 2 years of experience at that point. He wasn't an experienced attorney at that point. He was still a rookie at that point when he got for her.
I mean, the type of sneakers. What's his sneakers bar? Sounds rubbery. You mean Snickers?
Sneakers bar.
Snickers bar. It's a shoe bar?
I ain't eating
I'm not eating a Snickers bar.
I can't even eat Snickers bar because I'm working peanuts.
Ew. Oh, all right. Oh my goodness. We've got until I'm going to say the end of his testimony, and then I got to call it a day.
Yeah.
Information to the initial reports. That doesn't sound to me like producing additional discovery. That sounds like.
Objection. Counsel's testifying.
Counsel, would you like to respond?
I'll rephrase the question.
All right, so I'll sustain the objection. You may continue.
Thank you. Wouldn't you agree with me that what you are telling this reporter is that
Wouldn't you agree with
forensic
me?
examiners are
What
changing
did
their
he make?
reports or adding information to their reports, as opposed to your office is obtaining additional background materials related to the testing?
No.
Let's go to Exhibit 5, please. Exhibit 5, are you familiar with that?
Yes, I've seen this article.
Did you have a conversation of any type with somebody associated with PolitiFact, P-O-L-I-T-I-F-A-C-T?
Yes, again, this was an email conversation with a reporter that's credited with the story in Exhibit 5.
I totally wouldn't have done this. I would have emailed one person and I would have said, you share this with everybody. All I'm doing.
Yeah, I ain't copying and CCing.
And on page 2, about a third of the way down, there's a paragraph that starts quote attributed to you, correct?
Correct.
And then after identifying you, there's another quote attributed to you.
Yes.
And are those accurate reiterations of the email you sent?
Yes.
Could this exhibit please be received into evidence as defense? And in this
Sorry,
second
I'm
quote in this paragraph,
Maybe.
your quote is saying there just aren't enough marks on the fragment to make a conclusion one way or the other, whether the bullet fragment was fired by the particular rifle.
The.
That's what that quote says, but you have to read it in context with the previous sentence.
Context matters, bitch.
So it's your testimony that you're not referring to the rifle found by law enforcement at UVU, and you're not referring to the bullet fragment taken from the decedent's body? You're making a general statement about bullet fragment
He
analysis?
said, read it in context.
He didn't say that he did.
Read it in context. What's the sentence
How did you
before?
end up appearing on Fox and Friends News?
Wait,
being
what's
interviewed?
the sentence before?
Like many other media organizations, Claudia Cowan from Fox News emailed me, asked if I had any comment about the defense representation and its motion to continue and the media stories surrounding that. And I agreed to do a Zoom interview with Fox.
Did you discuss that with Mr. Gray before you did?
Not that specific. Again, I didn't discuss any of the specific media requests with Mr. Gray. We had the understanding that I should respond to the media requests as they came in.
How many media requests were there?
My memory is 8 or 9.
Okay, so you had a telephone call with TMZ, correct?
Yes.
And you had email communications with USA Today and PolitiFact,
Yes.
and you were asked to appear for a video interview by Fox and Friends.
Yes.
Are there any other media entities who you communicated with directly in any of those ways? Parenthetically, because we're only aware of these 4.
Like I said, I think there were at least 8.
8 requests.
Yes, and I responded to all of those. I had a telephone conversation with a correspondent for NBC. I can't remember exactly all of the other news organizations that had contacted me.
Did you in any way collect the resulting news stories in which you are quoted?
No, I have some of them. I didn't make a search to find everywhere that I was quoted and collect those.
Okay, we would like, Your Honor, to show Mr. Ballard Exhibit 7, which is a video. And this is going to help us. Thank you. May we publish Exhibit 7?
Well, not before it's admitted.
Okay, so
if you want
we'll
to
show it to Mr.
wait
Ballard.
information, Sure.
We'll show it to Mr. Ballard, and maybe if the clerk could just show the show it to the witness before it's published. Mr. Ballard, can you look at the screen actually?
We do get some news clips played in
Thank you
this.
for your patience, Your Honor.
Good.
All right, let's
Anything other than Novak's
the screens.
big ass
Okay, so we're
nose.
going to actually.
Thank God we only have the back of his head.
We're going to show it without the audio and ask Mr. Ballard.
It's like brackets.
It's like our
Don't tell Rackets I said that.
Mr. Ballard, is your screen on?
It's on.
Okay.
And it's playing.
Can Your Honor see it?
Yes, thank you.
They're not gonna.
They're not gonna show it, but he's gonna ask for the
Do you
audio.
recall doing this interview?
Yes,
Did you watch this interview after you participated in it?
I watched this story. Yes.
Okay. Is this, as best as you can tell, an accurate digital copy of that broadcast where you were interviewed by Fox and Friends?
I haven't heard the audio, but I believe it is based on what I've seen.
Okay. Well, I'm going to ask the court to receive it into evidence. And if Mr. Ballard thinks that the audio is inconsistent with what he previously said, we'll withdraw the exhibit.
With that proviso, no objection.
All right. Defense Exhibit 7 is admitted and may be published.
Thank you. We'd now like to play it. And just so Your Honor knows, the entire thing is about 2 minutes and 12 seconds. Maybe.
Courts and technology.
It says it's connected to the H.
The bullet that killed the
You want to
conservative
restart it now?
icon. In a new defense filing, attorneys for Tyler
Charlie Kirk are pushing to delay an upcoming trial hearing as new details come out surrounding the ballistics report.
Claudia Cowan joins us now with the latest. Good morning, Claudia.
Good morning, Lawrence and Brian, and also to you, Rachel. Nearly 7 months after Charlie Kirk was assassinated, lawyers for his accused killer are attempting to cast doubt on a critical piece of evidence, the bullet that killed the conservative icon. In a new defense filing, attorneys for Tyler Robinson say an ATF summary report, quote, was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr.
Look at that
Robinson.
smug ass
Prosecutors say
face.
that report is inconclusive.
You see
and
that?
doesn't rule out ballistics match to the rifle Robinson allegedly used or to any other firearm.
Oh my God.
Is
The
that necessary?
examiners were not able to find enough detail
Step.
on the fragments to be able to make a determination as to whether or not they can tie the bullet to the rifle.
Law enforcement sources tell Fox that when the bullet hit
Be
Kirk,
back.
it struck.
Mr. Ballard, was that your statement on Fox and Friends?
That was the statement that they chose to play.
Is that the statement you chose to make?
Yes.
And aren't you talking in that statement about the bullet fragment at issue in this case?
I prefaced that statement with the preface that I put on my other statements was that I'm not going to talk specifically about specific test results, but generally when there is a inconclusive result, these are the circumstances that could produce an inconclusive result.
So your testimony is that the statement that you just made to Fox and Friends is not referring to the bullet fragment in this case. That's your testimony.
Right.
So obviously your office, Mr. Ballard, and apparently TPUSA were concerned with what I'm going to refer to as the media spin on the contents of the motion to continue, correct?
Can you
Your office was concerned, and TPUSA expressed concern about the way the media was, I'm just going to use the word spinning, I think we all know what that means, the contents of the motion to continue.
I can't speak for TPUSA because I wasn't privy to that phone call. But our office was concerned, yes, about the prejudicial media reports.
So my question is whether the goal of these interviews was to influence the reporting, or was it to change the public, what you were concerned was the public perception of the case?
The goal of these interviews was to respond to the specific media inquiries that were being generated by the misinformation that was circulating about the bullet testing.
But there's a reason why counsel who are subject to the rules we're talking about here, and especially prosecutors subject to these rules and the court orders, choose to engage in extrajudicial statements. I understand your position is it's an extrajudicial statement which is permissible under the court order and the rules. I don't agree with you, but I understand that's your position. So what I'm just asking about is what you hoped to accomplish. Was it to change the media content, or was it to influence the public perception of the evidence in this case?
Objection, asked and answered.
He really thinks
I don't
he's
think I
got something
recognized
here.
Or if I did, the answer wasn't responsive. Mr. Ballard's response to the last question was, the goal was to respond to media inquiries. Was that the only goal, just to respond to media inquiries? I'm sorry.
Counsel, I need to rule on the objection before we
Absolutely.
move forward. I'm going to overrule the objection and allow that question to be answered.
The goal was to respond.
You think he
to
had the period
substantial
make them
undue
Yeah, he really thinks he's got something here. And her borrowing my glasses, they're not prescription. They're only blue light blocking glasses that I use when I'm on the computer for long periods of time. So they're fine. They're not going to affect her eyes. They're actually probably better for her eyes than staring at my computer screens without anything. Just before I get hater comments about letting her use my glasses, they're blue light blocking glasses, people.
People can be
I know
so
they're
crazy.
I know there's always haters ready to pounce on my mom skills. Just,
judicial effect of the media stories.
What evidence do you have that there was undue prejudice? We haven't picked a jury yet.
The-
Oh, pop meat fucking kettle. Excuse me. Yeah, you tell him. What evidence is there undue prejudice? You tell him. Isn't that what they keep saying? There's undue prejudice. Prejudicial to the prospective jury.
Yep.
You haven't picked a freaking jury yet. Exactly. What she said.
Tell him, Miss Glee, you have objections.
You tell him, baby girl. Oh my goodness. But I mean that is... Excuse you. Can I talk now? No. Well, an hour and 35 minutes into this, and that right there, I think, is the most clippable moment from this hearing so far. Is how is it prejudicial? Well, I can say the same to you.
Since that the reason that we were concerned about those statements is that it was producing media. We were concerned about the media stories that were saying, first of all, that the bullet in fact did not match, and that therefore we had no case, that we had brought a groundless prosecution. That was our concern.
See,
Which is an issue that can.
which is what I was saying. You're always talking here. Novak's always talking about being unfair to the defense. Well, that story being out there and saying that they have no case is prejudicial towards the prosecution. And heaven forbid I just said that freaking sentence. Oh,
Just as much as the defendant has constitutional rights, so does the state.
Can you say pecuniary advantage yet? Can you say pecuniary advantage? No. Well, we're getting closer.
I can't even say that, so she's better than me.
Be addressed through jury selection, correct?
I can say the same to
It's an
you. If you have a problem with, so here's my, like, I'm not a lawyer. I never will claim to be one. At this point in my life, I don't want to be one. However, my thing is if you get a prejudicial jury, you didn't do your job of voir dire good enough. You have a problem with your voir dire skills. Voir dire, I've heard both. I don't know exactly which one is accurate because I don't care either way.
Yeah, I don't think nobody knows which one is which.
However, if you get a prejudicial jury, you suck at your job as a lawyer. I'm just saying. And I don't have to be a lawyer to know what a good lawyer is. All I have to have is 2 eyes and a half working brain. Ma'am. Right? Okay, 2 eyes. Yeah, 2 eyes and a half working brain.
Issue that could be addressed through an expanded jury questionnaire, correct? It's an issue that could be expanded through additional peremptory challenges if the court deems it appropriate, correct?
That's another way.
It's an issue that could be addressed through individualized voir dire, correct?
Okay, he said voir dire. He only talks when I talk. I really hope that these are. I really hope that these issues are shot right back at him when he claims about anything being prejudiced towards the defense.
Oh, you're going to laugh tomorrow when he makes his argument what he thinks the remedy should be, and I can't wait.
Yes,
It's an issue that could be addressed under the appropriate circumstances through a change of venue, correct?
perhaps.
A couple more questions, and then if I have any more time, I'll reserve.
We have 28 minutes remaining.
Oh, wow.
so.
Ms. Visser scared me. Before you decided to return these phone calls, answer these emails, and accept an invitation to appear on Fox and Friends, did you ask this court to clarify its order in light of the way the media was interpreting the motion to continue?
No.
Did you reach out to anybody in Mr. Robinson's defense team and say, you know, whether you guys did this intentionally or unintentionally, the media has misinterpreted your pleading. Can we do something about that judicially as opposed to extrajudicially?
No.
And I have about 5 to 10 minutes left, so we are going to
I
have
have
to
no further
call this
questions for Mr.
a little bit early.
Yeah, I believe he's almost done with redirecting. That should probably be a good.
Actually, I think this is where we're going to call it because they're taking a little bit of a, not a break, but a pause.
Yeah.
So we will return to this tomorrow for part 2.
Yeah.
Because we are an hour and 38 minutes into this.
Yeah, we got a lot more. They got this remedy, got cross-examination, technically redirect from the state, and then the elected official will testify.
Yeah, it's a long one, and this is why I don't do those live. We do them on our own time because
I streamed it live in Discord. It was brutal.
we don't. Girl doesn't have time to sit. You know, life. Things will be, ma'am. Things will be different in the fall. Excuse you.
He will hopefully be bound over for trial by the time the fall comes.
Avery. So things will be different in the fall when she goes to school and I have more time during the day to myself. Honk. Honk. But anyway, I have us set up to redirect over to AJ. She starts at 6.
Yeah.
So you've got about 40 minutes, but give her a follow over there and tell her I sent you. And I will see you guys tomorrow, 2:30 p.m. We will continue this little shit charade.
Yeah, there's still a lot more. We ain't even scratched the surface yet.
Yeah, and a lot more opportunity to make fun of Novak, which I am all here for. And guess what? If Novak saw that I was making fun of him, he would probably laugh at it and go, Well, that sucks. But he wouldn't take it personally because he has a pair of balls. They might be small, they might be tucked, but they're there. Flash fan, any final thoughts?
Nah, I mean, just get ready. You ain't seen a lot of it. You still got to see his argument, so still got about an hour with him left, even though it's cross-examination and redirect examination. He not finished. And he asked for a remedy. That's why I said y'all should probably bring boxing gloves or some type of something to bite on tomorrow.
I got bullets. Does that count? No. The old phrase, bite the bullet. Anyway, would you like to get us out of here today?
Yes.
3.
Mahi.
Yeah, that's my.
Mahi.
Yes. Would you like to say yeet on the count of 3? 1, 2, 3. You want to say yeet?